The Speaker.
Member, leader of the House, and Whip, could you all please summon? All right. You have 5 minutes of original time left, and you're entitled to 15 minutes extended time. So if you intend to go beyond the 5 minutes, I'll invite you to request the extended time at this time.
Might I so request at this juncture, Madam Speaker?
You may proceed.
Might I thank you warmly. Madam Speaker, before we took the break, I was about to demonstrate that the assault weapons of which we speak, which falls in the class of prohibited weapons, including the well-known AR-15s, the Uzis, and as Minister Stuart Young indicated on advice from the experts in the police service and otherwise, these young men out there now, persons, criminals, they are making the regular Glock firearm automatic and sticking in a magazine that could carry 41 rounds, 33 rounds, and presenting a serious cultural shift for us in Trinidad and Tobago. Madam Speaker, in the so-called Plummer case that the member for Oropouche East spoke about, it had to do with these assault weapons, a number of them, and as well a handgun. And shortly after, the police found another 9. So we did talk about the amendment to the Firearm Act, which we got support from the other side to treat with, so that if you are caught with more than one. So it was after that event, Madam Speaker, that the police made a request of us to look at this law again. We are not here by whim or by VAPS. We are responding to the call of the Trinidad and Tobago Police Service, the only organization under the Constitution and under the law that is tasked with the business of dealing with crime, preventing crime, preserving the peace, detecting crime and other infractions of the law, as the statute defines it. So in response to the police, we absorb the ideas intellectually, and he said, yes, you have a prohibited weapon, we should be able to deny bail. You have grenades, hand grenades, another weapon of war. One was used in an escape out of the prison on July the 24th, 2015. Faithfully and thankfully, it did not detonate. You can have a platoon of troops, a patrol of police and soldiers from the IATF. One such instrument could create a serious problem. It is a serious problem. And we have a very loose culture here. We have to deal with it. There's mayhem out there, Madam Speaker. We are now hearing that member for Urupuchi spoke about someone who was shot in the hospital. We are now hearing in crazy Trinidad that that deceased man in the hospital was the wrong target. He was not the intended target. This has happened before. So we have a serious culture out there. Somebody put on a forensic, the crime scene suit and walk into the hospital. We have to improve our security at our institutions, our schools, our hospitals. We have a job to do. We have to change the culture. These things happen in other countries, you know. But when you walk in England, you just know in the back of your mind, you are being photographed 54, 60 times per day. If you do wrong, you are likely to be caught. That's the culture. In the United States, you saw something happen, within 1 minute, 7 patrol vehicles on top of you, all the police on top of you. Brutal sometimes, but that happens. That's the culture in those countries. I spoke to the Vice Minister of Public Security of China only yesterday at my office, who paid a courtesy call on us. And we are a population of 1.3 million. China is 1.4 billion people. Madam Speaker, I asked the Vice Minister about their murder statistics. He told me back in about 2000 and thereabout, they used to have 30,000 murders a year in China, across China. And it was intolerable and unbearable for the government at the time and for the people of China. And they have been able since then to reduce that figure by about 10% on a yearly basis. Right now, their figure is about 8,000 for the year in a population of 1.4 billion people. That, Madam Speaker, is about 0.07 per 100,000. That's a fascinating rate. So I asked the Vice Minister, what does he attribute to that outstanding rate? In a land where they have guns, they have all kinds of implements. And the Chinese are the most creative people in the world, as we would have seen. He tells me a number of things. He tells me that their whole social network to deal with the impoverished and so on, they have a strong program along that line. He said they educate for discipline. Education is not for just get a job and get a degree. Our education is for discipline. Well, of course, you have to look at the cultural context, the historical context of China through in the Cultural Revolution and so on. It's a different kind of people to the free, laissez-faire people that we have evolved to be. He told me their prosperity as well. China, as we know, have been able to move millions of people from below the poverty line as established by the international family, United Nations. But yet, in 2008, when we tripled our GDP, we had the highest murder figure ever, 550. So while he explains to me that prosperity is a palliative to these murders, we have experienced here, because our standard of living and our quality of life in Trinidad is comparable to countries anywhere in the world, realistically speaking. We eat well, we dress well, we play well, we dance well, we are having a good time. And still, we are having this phenomenon, but Trinidad is a country like that. But most of all, he spoke of judicial cooperation. Their system is a little different to ours. And the judiciary, he explained to me, are a lot more cooperative, I'm using his word, to the government in its fight against crime. And the death penalty is a reality. They don't have to go to no privy council. It all happens inside of China. And it happens very quickly. So at the end of the day, there's a culture in that country far removed from the culture that exists here. I don't propose to discuss the whys or the hows or the propriety or impropriety of that. But the bottom line is, it is a different culture altogether. But we have a culture of mayhem out there. And when a criminal walks off the street, walk onto a ward in the midst of other patients, you could imagine, in the midst of other family members who come to visit patients, in the midst of these nurses who left their homes, their children, their husbands, their wives to go and work, and have to be listening to 10 gunshots and talking about 10. The Minister of National Security alluded to it. It is not one shot anymore, you know. They killed a little boy in my constituency. It's about 9 bullets they found in the little boy's body. A 14-year-old or a 16-year-old. Sometime last year, his parents are still in grief. I still am, because I knew the young man. And I got to know him even more since his passing. And in Jamaica, there's a so-called shower posse. They got their name because they're not killing you with one shot. When they come, they shower you with bullets. And we have a lot of copycat here. Southeast School reported today, shooting taking place. Bullet penetrates some classroom, and a teacher and a student or so got injured in that. And these children have to be going to and from this institution, an institution that from the reports I got from the Ministry of Education have been performing particularly well over the last few years and on the rise academically. But they have to deal with these issues, Madam Speaker. It's all part of the culture, wanton shooting. When a man tell you now, going for a gun to come back, long time you call that gantamouche, grand charge. Now when a fella tell you going for a gun, he don't have to go far. And that raises the point. If you do not want to stop them first offense, wanting, you leave them with bail to go and do it again. The statistics showing that. But more than that, the criminals are far more clever than some of us. And if it is that you can go around and you don't have to fear not getting bail because this is your first time or you didn't get a conviction or a charge before, what they will do is take our 16-year-old sons and grandsons and let them who has never had an interface with the police be the mules to carry the gun to the hit scene, they commit the crime, and the little fella carry it back. That is how the thing does work. So they can't be wiser than us. We all had gate. Well, no, not me. Those at my age would not have had that. But we all have some brain and we have some sense. And we are supposed to be representing the public interest, every one of the 41 of us. So we have to use what we have, and we have the power of lawmakers to respond to this culture and to try to change it for the better, as China did, from 30,000 a year down to 8,000 a year. We are no less than the trees and the stars. And it still leaves room in 7A of the bail amendment that we did in 2019 for judicial discretion. Still does. So, Madam Speaker, I hope that having rehearsed some of these basic facts and elements, without having to go into the actual terms of this very short bill, it is simply, as I said thrice before, to adjust the bail law to accommodate the 2 new offenses that we created on the request of the police, which met and squared with our own intellectual assessment as to the propriety of it, the worthwhile element of it, the good sense of it. And it is designed, in my view, to create and begin the creation of the new society that we have been talking about. It is to change the culture. The criminals must know that the balance doesn't favor them. And on the question of balance, every time, because no right, they could criticize me how they want. I'll just tell them about Cambridge Analytica. Because that was the gravest intrusion in people's privacy that we could ever have known about. Exposing people to extortion and all kinds of things. Of course. And all manners of things. We have to find a balance, and this is well known. This is trite even. We have to find, as we make laws, a balance between the constitutional rights and respect for them, and at the same time, individual rights. And this balance has to be worked out on an ongoing basis. When they came in 2011 with the anti-gang law, we knew that to take away bail for first-time anti-gang law. We knew that to create an offense of being a member of a gang, or harboring a gang, or hiding a gang member, took away a bit from the freedom of the society under the Constitution. But we did it, and the Constitution makes provisions for doing it. And the court, as you would have heard on umpteen occasions, have upheld the correctness and the rectitude in so doing it. So it's not new to us, Madam Speaker. And this is just another occasion for us to gang up on the criminals together as parliamentarians in the general public interest with a view of changing the culture, with a view of building a new society. That really is what this is all about. And I must ask again as I wind to a close, why would the UNC, my colleagues on the other side, oppose this, seeing that they did it before? They did it. That is to say, create a condition for the restriction of bail for first-time offenses. Why have they changed from that stance to today? It is for them to explain. And we heard from the Minister of National Security some elements of certain behaviors, and I am personally familiar with some. We saw this happen in Jamaica, you know, where politicians mollycoddled over years with unsavory elements. And that affected their country in no end, socially, economically, politically, up to recently with the Dudus Coke issue. We don't want that in Trinidad and Tobago. So we all have to be strong. We all have to be watchful. Because while that kind of thing may bring short-term benefit or appear to bring short-term benefit, in the longer term, gets a little difficult. More than a little difficult, Madam Speaker. So I urge my colleagues to think. As we go forward, and I urge my colleagues in the circumstances to not be afraid to love, not be afraid to represent your constituents stoically and manfully. Not be so politically myopic that because the government is bringing something and it requires a special majority, you will not support it. And as the member for Oropuch East said, they have an open mind. They are open to the principles here. And the reason why they did not vote against it expressly in the Senate is because they agree with the principle. But what they have a problem with is the question of the possibility of framing. I began my presentation by demonstrating that this framing thing is a fallacious argument that is of general applicability. It is not confined only to this law. And secondly, in the event that an officer does that or tries that, there are a whole scheme of due process and evidential and administrative elements to protect against it. And of course, as my colleague, the Honorable Attorney General, is just reminding me, and it is worth putting on the records, when you are a public officer, you find yourself exposed, if you do that, to the old offense of misbehavior in public office, a very serious offense with a very severe penalty. And perversion of the course of justice could apply to anyone, public officer or not. And it is a very serious state of affairs. And we can now boast we have done a number of things to protect the citizens against the abuse of police and prison and customs and immigration and other such powers. And when we come back after the elections, Madam Speaker, you will continue to see legislation precisely along those lines in the protection of the people. And with those few words, Madam Speaker, urging my friends on the other side to think and to act as members of Parliament should. And how much more time I have, Madam Speaker? I see my friend is jumping up like a wooden inanimate object.
51. You have 3 minutes.
3 more minutes. I want to protect my friend, the member for Naparima. I see him jumping up and down like a wooden object. Yes. So, Madam Speaker, I would like, on behalf of the people of Laventille West, to thank you profusely for an opportunity to have stood here and spoken in their best interests. And they will know from my contribution that when we act as members of Parliament in their interests, we do so, Madam Speaker, as we must, taking our oaths, Madam Speaker, to do good and to do right unto all men. Thank you very much, Madam Speaker.
Madam Speaker, thank you. I know not the tallest of the members here, so I have to ensure that I do what is necessary to catch your eye. Madam Speaker, I never thought that it would fall upon me to correct the Honorable Attorney General on a matter of law and on a matter of fact, Madam Speaker. You see, when I heard him speaking earlier today about Singapore, I knew that he was stepping into a territory in which he knew little of. So I asked my staff, I thought I had heard wrongly. So I asked my staff, did the Honorable Attorney General say that if one is convicted for possession of a firearm, one could face the death penalty? And I got the response from my research staff. He said, the Honorable Attorney General, that in Singapore, the penalty for possession of firearm is the death penalty. Madam Speaker, I would wish to inform the Honorable Attorney General that in Singapore, the penalty for possession of a firearm is not the death penalty. Madam Speaker, and I refer, you see, we have to be careful with language, we have to be correct, we have to be precise, and most of all, we have to be factual. Singapore has, and I will quote from, and I could give the source, Singapore is one of the toughest gun control laws in the world, and according to their Arms Offences Act, unlawful possession or carrying of a firearms is not punishable by death. Incorrect. However, using or attempting to use arms when committing a scheduled offense is punishable by death.
But for Diego Martin notice, do you want to make an interjection?
I will have to speak in this debate.
Right,
yeah.
Thank you. Please continue.
And when I go to the scheduled offenses, which are punishable by death, 130B says, and they give examples, while committing or attempting to commit piracy, the person commits murder or attempts to commit murder or does any act which is likely to endanger the life of another person. And they go on to give examples of what will occur that will entitle someone to the death penalty if they have possession of arms: genocide, mutiny, assault in desertion and mutinous situations. So, Madam Speaker, I've just corrected that for the record, Madam Speaker. Madam Speaker, but this is not the first time. In a previous debate with the UNSCR, Security Council Resolution 2231, 3 times I mentioned that it exists. And yet the Honorable Attorney General got up and said, the member for Naparima said it does not exist. And he could use a phone or something to call the UN. And when I went to the United Nations, they shook their head. You see, Madam Speaker. Madam Speaker, in respect of components, I understand that the member for Port of Spain North, St. Anne's West said that the components are related to an AR-15. But, Madam Speaker, I have with me the police diary, station diary, and the reports here. And they said, and the court, the police could not tell the court what weapon the components could build. It could not. And it seems to me that the Minister of National Security knows more, or the National Insecurity, knows more about weapon building and components than do the police, Madam Speaker. Madam Speaker, I was taken aback. I was taken aback by the member for Port of Spain North, St. Anne's West, when he read what one would consider internal police documents, special branch reports. Madam Speaker, I had the privilege of working with Dr. Cuthbert Joseph when I returned from studies in Canada. And every morning he used to get special branch police reports. And he would not let me see it. He would not let anyone see it. Because those, as far as he was concerned, those were classified documents. In the United States, that kind of internal police information is not for mass consumption. And you see it on television. You see it on television when they ask congressmen or members of the Senate, they inform the television or the host who is interviewing them that they are not authorized to give classified information. That's a problem in Trinidad where we have government officials who do not understand the tenets and the protocols of governance. But, Madam Speaker, I have a problem with members from the other side quoting unknown documents and threatening us on the other side. Madam Speaker, I think it is something that we need to look at in respect of the operations of the Parliament. It's something we need to look at. Often we hear they quote a document, the source is not properly identified, the date, the time, the information is not corroborated, and it is given in the public domain. It reminds me, Madam Speaker, and we have to be careful lest we repeat the evils of Emailgate, where accusations are made against citizens of this country on the flimsiest of information. Madam Speaker, another point I think it is important for me to raise in this House, this Honorable House, is the fact that on the other side, they see consensus, they see collaboration, they see this discussion as a situation in which their side, their view, their perspective alone matters. Madam Speaker, I recall in an earlier iteration of this bill, earlier this year, in a bill that required a special majority, therefore they needed our support. Madam Speaker, we suggested eight amendments, Madam Speaker. 8 amendments we suggested. Not one was accepted, Madam Speaker. It leaves us on this side to believe that their idea of consensus, their idea of discussion, their idea of working together is their way or the highway. And, Madam Speaker, that is inconsistent with the spirit of the Constitution, which particularly with respect to the 3/5 majority situation, which suggests the need for collaboration and interaction and debate and an honest appreciation of the other's perspective. Madam Speaker, we are here today to discuss the Bail Amendment Bill number 2 of 2019. This is a sequel of the Bail Amendment Bill 2019, which was discussed in this House on July 31st, earlier this year, 2019. Madam Speaker, I'll not be surprised if sometime in the not too distant future, we will be called to discuss Bail Amendment Bill Part 3, where one can only presume, given the penchant of this government to pass more and more draconian legislation, that we will once again be summoned to this Parliament to be abused, Madam Speaker, not to debate, but to be abused. to be called unpatriotic, and pressured to pass bad law. As we meet today in this distinguished house, Madam Speaker, I wish to pay fulsome tribute to a distinguished son of the soil, the late Mr. Wayne Chance, who lived his life by seeing the good in his fellow man rather than the negative characteristics, especially of the disadvantaged. Madam Speaker, as I said in this house on July 21st, I would not have minded if we were here to discuss plans to help inner city at-risk youth to be gainfully employed, to be encouraged to acquire employable skills, to learn discipline, to have a sense of belonging now provided mainly to them by gang leaders. I would have relished, like Comrade Chance, sharing ideas on how we can use the cadet force, the 4-H clubs, the police youth club, and my lot and my part to rehabilitate young people and ex-prisoners so that they can make a worthwhile contribution to Trinidad and Tobago and effectively deal with crime. That would be a most profitable and spiritual use of our time. Madam Speaker, what is the Bail Amendment Bill? This legislation was brought into law in 1994 and was amended many times, and most lately in 2015, in 2016, 17, 18, and earlier this year, 2019. It will be recalled in that debate that this bill and its immediate predecessor, the bill deals with a number of troubling human rights, constitutional issues, and democratic principles. As I said before, Madam Speaker, it was this finance minister, the Honorable Colm Imbert, speaking in Parliament on a bail amendment bill on Friday, March 13, 2015, who questioned the constitutionality of the amendments before the Parliament. Madam Speaker?
Somebody has a device that is distracting me. Could I ask the member to go outside, silence their device, and they could return? I also want to ask the members on the front bench to my right to please contain their tones.
Madam Speaker, thank you. I quote the Minister of Finance, then member of opposition for Diego Martin Northeast. He said, the constitutionality of these series of amendments to the Bail Act was very questionable. All it will take is one aggrieved prisoner to take this matter all the way to the Privy Council to get a determination as to whether all these amendments to the Bail Act are in fact allowable under a 3/5 majority. I could give way to the member for Diego Martin Northeast to find out if he still has those views or if he has changed his mind.
Apparently that has happened.
Okay. Thank you. Thank you, Madam Speaker. Thank you. He cannot indicate, cannot with a straight face tell us he has changed his mind. So, Madam, according to the explanatory notes, this bill would provide for the inclusion of the offenses of the possession of firearm or prohibited weapon for the purposes of trafficking under Section 9A of the Firearm Act, Chapter 1601, and possession of a prohibited weapon as offenses which a person would be denied access to bail for a period of 120 days under the Bail Act, Chapter 460. The second iteration of the 2019 bill now means that a person charged with possession of a firearm under Section 9A of the Firearm Act or possession of a prohibited weapon, regardless of whether or not it is their first offense, will not be granted bail. And a prohibited weapon means artillery, automatic firearm, or bombs, grenades, or other like missiles. Madam Speaker, it will be useful at this juncture to identify what bail is, what is its purpose, and why was it developed in a democratic society to protect the rights of citizens. According to the Legal Aid Society of New York, it says bail is only supposed to be set in cases where the court deems the accused person to be a flight risk, meaning that they are unlikely to return to the court on their own. The purpose of bail is to ensure that the person who pays bail or who has bail has bail paid on their behalf will come to court on all their court dates. While it is understood that the right to bail may be curtailed in certain circumstances where it is warranted by the gravity of the crime, like murder, treason or rape, or the ability of the individual to harm witnesses, in most jurisdictions, it is the court which decides whether or not a person is granted bail, and not the legislature. The primary purpose of bail is to ensure that a person does not abscond from the courts. However, those opposite appear to be using it primarily as a punitive mechanism, mainly to plaster over inadequacies in our judicial system and in our approach to policing.
Please, Madam Speaker, standing order
4410.
Okay, so Member for Naparima, 4410 means that you are reading. We know it's a debate, and I am sure that you are articulate enough to separate yourself from your notes. Of course, if you're doing an extract, you can do some of that. Okay, so please proceed and be guided.
Okay, thank you, Madam Speaker. I'll be guided. In my contribution today, I propose to look at this bill from the perspective, from the perspective of a layman, not a lawyer. And may I just say that lay persons constitute 99% of the population. And I have 7 concerns from this perspective. The first one, my first concern, is that it seems to have been developed in a very ad hoc manner. Why were these amendments not considered when the bail amendment bill was brought to the House in July this year? What new information not available to the drafters then has brought us here today? Were artillery, automatic weapons, missiles, grenades, or bombs not within the contemplation of the drafters of the previous bill? Madam Speaker, this is lazy, vapid, shoddy, inadequate research on the government's part. This is unbecoming of a society, a country that is aspiring to first world status. And that is why we repeatedly call for joint select committees to look at the bills holistically, to take on board all kinds of scenarios, all kinds of perspectives. So at the end of the day, we come up with good legislation, Madam Speaker. It is my hope, Madam Speaker, that we would not be summoned to Parliament tomorrow or the day after to increase penalties in a failing desire on the part of this government to stamp out crime in our society. Madam Speaker, my second concern is the presumed assumption by this government that increased punishment and more legislation would lead to a reduction of crime.
4410, please. Unbearable.
Okay, so, all right. Member for Naparima, proceed, but again, you know, it's a debate, and you know, I really don't want to stand on that, but it's a debate, and therefore, as again I said, you could quote extracts to some extent, you know, but I'm sure you can contribute without being so tied to your country.
Thank you, Madam Speaker. My second concern is the presumed assumption by that side that the more and more draconian legislation and the more laws that you pass would lead inexorably to a reduction in crime. Madam Speaker, this is palpably false. Last week, we had a situation, and I have to read the names. Jamelia Chase, Carrie McEachran, and Michael Grimy Walker were shot and killed in Maloney. Madam Speaker, a Newsday report indicated that their deaths were as a result of gang warfare. So the 3 deaths as a result of gang warfare. But we were told by the Attorney General, the Honorable Attorney General, that the Anti-Gang Act would give the government a fighting chance in the war against crime. He said that he knew the names of gang members. I don't have to read for this. He knew the names, he knew the addresses, he knew where they were, and he knew the number of gangs, Madam Speaker. But yet today, in the last 6 days, we had 4 murders in 6 days that were gang-related, Madam Speaker. Madam Speaker, today we ask the question, with a 600 million SSA, strategic agency, right? And gang units in almost every police division, and armed with anti-gang legislation. Why are they not able to effectively monitor gang members, anticipate their actions, and stem their murderous activities?
I'm on a standing order. I really must rise on 4410. Madam Speaker, there's a rule against it.
Yeah, but I think he's making an effort. Yeah. Please proceed. Don't. And while I'm giving you some latitude, as the AG said, there's a rule, and let's try and comply.
Yes, Madam Speaker.
Please.
Madam Speaker, and my third concern relates to the concept of the separation of powers. Under our system of governance, we have 3 independent agencies: the legislature, which makes laws, the executive, which carries out the laws, and the judiciary, which adjudicates on the law. I'm looking at you, Madam Speaker. In my area of study, we also have the media, the 4th estate of government. The 3 estates and the 4th estate. The media is supposed to provide information to our citizenry so that they can make informed decisions with respect to governance in the country. May I remind the learned Attorney General of the Privy Council's ruling on this, and he quoted this in another place, and he also did it today. And the Supreme Court of the Judicature, and the case, and I have it here, the State versus Karate, right, in Mauritius, 2006, UK Privy Council, UKPC, 22nd March, 2006, the State versus Abdul Rashid Karate. Madam Speaker, the Privy Council in that judgment made, and I quote, and I want to read it because I want to be precise, not like the Attorney General that comes and gives information, and when you check it, you realize that there's a level of imprecision. Madam Speaker, and I'm quoting here, that decisions on bail, I want to read it slowly, were intrinsically within the domain of the judiciary. Madam Speaker, I didn't make it up. It is here. The Privy Council further dismissed the appeal of the state. The Privy Council further dismissed the appeal of the state of Mauritius against the decision of the Supreme Court, which concluded that, and I'm going to quote, because I heard him quoting this document, and I thought it was something, a different document from which I read. I quote, in the judgment, it was not in accord with the letter or spirit of the Constitution, right? As it then stood to legislate so as to enable the executive to overstep or bypass the judiciary in its essential roles. So the Privy Council is telling the government, the state in Mauritius, that they did not agree with the state's request that the state could pass laws which would seek to curtail the jurisdiction of the judiciary. Madam Speaker, it concluded it dismissed the case against the state. The state wanted to, in fact, it passed legislation to circumscribe the granting of bail, to tell the judiciary that it could not grant bail in certain offenses dealing with drugs. Madam Speaker, they had the scourge of drugs, we have the scourge of guns. Madam Speaker, it concluded by stating, and I quote, to remove the court's role, and the Attorney General has to deal with what I'm reading. Either I'm reading it wrongly, I'm misquoting, or my interpretation is wrong. He has to clarify. To remove the court's role, and in the process to prescribe automatic detention in custody pending trial whenever prosecuting authorities have reasonable grounds to arrest for a prescribed drug offense. The new scheme would contradict the basic democratic principles of the rule of law and the separation of judicial and executive powers, which serve as a primary protection of individual liberty. End of quote, Madam Speaker. In fact, the court, notwithstanding any of the readings, the court dismissed. It ended up, the court dismissed, the Privy Council dismissed the appeal of the state against a judgment by the Supreme Court, which upheld the separation. Madam Speaker, the European Court of Human Rights ruled on February 8, 2000, and I have the ruling here, the case of Caballero versus the United Kingdom, application number 32819/96. The European Court of Human Rights accepted in a unanimous judgment, I'm quoting here, the UK government's concession that the automatic denial of bail pending trial was a breach of Article 5.3 and 5.5 of the European Convention on Human Rights. So, Madam Speaker, what that is saying is that we have to be careful, and my perspective, my reading, is supported by the member for Digo Martin Northeast, who years ago indicated that all that would be required is for some aggrieved prisoner to take this matter to the Privy Council. And I warn the Attorney General, because I read frequently.
It seems that a member was probably having a little pain, and therefore, if the member is having pain and needs to groan, I'll invite them to go outside. I think we do have a sick room where painkillers are available. Okay? I would like to hear the member for Naparima. I believe the Attorney General has an opportunity to wind up. Yeah. And I believe the member for Digo Martin Northeast, if he wishes to join the debate, he can do so in due course. Please continue.
Thank you, Madam Speaker. You see, my job in the opposition is to provide an alternative perspective, right, that they could take on board, or they can dismiss, or it can assist them in coming up with better legislation. Madam Speaker, I note Senator Choate's comment on November the 12th, 2019 in the Senate, in the other place. And it's on, I quote from Hansard on page 103. And she said, quote, "I oppose this proposed amendment. I could be standing alone at the end of the day. So be it. But I think the proposed amendment is unconstitutional." She is a lawyer. I am not a senior counsel, but I can read the law. And when I read the law, Madam Speaker, I see that our Attorney General may misinform himself, or he may misadvise himself. No wonder we lose a lot of cases in the Privy Council, Madam President. But I continue for Senator Choate. She says, "But I think the proposed amendment is unconstitutional. It is not warranted in law." The 12th November 2019. Please listen, instead of getting in foolish discussions at the side. It is not warranted in fact, Madam Speaker. And I believe that from the contributions I have heard, that we need to refocus, and this is something we need to think about in this Parliament. We need to refocus on what test we should be applying when we treat with applications for amendment of legislation requiring a constitutional majority. Madam Speaker, my learned friend from Urupuch East indicated that they come with an attitude of arrogance in this Parliament. Madam Speaker, it is either you agree with us or you're you're unpatriotic. Either you agree. Madam Speaker, I always thought that if you wanted to get consensus, you wanted to get someone to agree with you, you would listen first to what the other side has to say. And if there is any merit, you treat with the arguments. What we get here is, and I have a concern because the Attorney General speaks after me, and therefore I get ad hominem attacks, I get slippery slope attacks, I get what they call putting a false narrative and arguing against that. I thought, Madam Speaker, I taught at the university in communications, and they have what they call false arguments, fallacious arguments that you could. If you cannot attack the point, you attack the person. That is one element. That happens, and that is why I leave whenever he speaks, Madam Speaker. Madam Speaker, Senator Choate went further to say, and I quote, "The Bail Act provides that if the prosecution is dissatisfied with the decision of a magistrate, or if an accused person is dissatisfied with the decision of a magistrate, there is a legal forum for either the prosecution or the accused person to go before the High Court." So the prosecution, if they are in disagreement with the magistrate's adjudication, can go before the High Court and ask for bail to be revoked, or that conditions be placed on bail. Madam Speaker, what is wrong with judicial officers making a judgment as to whether or not bail should be granted? There are so many instances, so many variations of situations that could bear upon the decision to grant bail or not. But here we are coming carte blanche, one size fits all, no bail. Why it is in this parliament, the hand of justice weighs heavily against the average citizen, particularly the poor, those who cannot afford a good lawyer, Madam Speaker. And that's why my heart grieves. I could get, in fact, they give threats every day in Parliament. Madam Speaker, you don't hear it.
Your original speaking time is now spent.
So much?
You are entitled to 15 more minutes to
Thank
wind
you.
up.
Thank you very much.
I just want you to be careful on the road you're traveling now.
Okay, thanks very much. So the question is, what is so wrong with the approach that exists under the Bail Act, Madam Speaker? Why is the government's only solution to curtail the jurisdiction of the courts? Is this not because they feel they are monarchs of all the survey and their dicta?
Arise on 4410 again.
Madam Speaker, I wish to remind the member for San Fernando West that this is not Iraq. This is not Tikrit, okay. Madam Speaker.
All right. 1 minute. One minute, please. It didn't appear so to me. So I'll ask you to recoil and proceed. Okay? Yes, please.
I withdraw. I wanted to make the point, I just wanted to make the point that in certain countries, the tendency is to curtail the judiciary. But we have a tradition, a Westminster tradition, that speaks differently and governs the way we operate, Madam Speaker. Madam Speaker, the question of proportionality, and I'm not a lawyer, it comes into question, especially when one considers, and this is a word I had to learn, the deeming aspect of the law is concerned. Madam Speaker, this bill essentially seeks to deny bail to first-time offenders. Once you are in possession of, or close to, or in the same house with, or in the same car with 2 or more weapons, a citizen can be denied bail and deprived of his freedom. What this means is that any time a citizen enters a taxi, he has to open the trunk, not so to ensure that there are no weapons inside there, Madam Speaker. Yes, it means to that, because if I am held in the car and I say that I do not know the source of that weapon, the driver is going to say that I brought it, so they will take all of us down. That is a fact. And if I'm wrong, I stand to be corrected. And I would like to be corrected on that matter. I'm not speaking of guilty persons, madam. We have to be clear. And I think the member for Oropuch East made the point. We are all for the guilty paying the full brunt of the law. We want to be tough on the criminals. We live in Trinidad and Tobago, but at the same time, we have a sacred duty, Madam Speaker, and will not be browbeaten from working against the interests of the average citizen of Trinidad and Tobago, and ensuring that there is a proper balance And we feel that the balance could be gained by the amendments which we suggest. And for heaven's sake, we made 8 amendments in the bill. You did not accept one. Not one did you see any benefit in. And we still supported it. Madam Speaker, it cannot be that it is the PNM's way or the highway. That will not happen. Not while I'm the member for Naparima. I will stand up and represent the 15,000 persons who elected me, Madam Speaker. Madam Speaker, we have spoken about Sadiq Bash, right? We have spoken. This is not something that we, abracadabra, we conjured up or nothing. It happened in this country. And all of us on this side. I remember, Madam Speaker, in 2000, when the police raided PASU office in central Trinidad, every Friday evening, we used to be worried because the police will lock you up, not in daylight. It's 10 o'clock in the night, and there's a reason for that. And we passed around books, how to survive in remand yard if you are not accustomed to that lifestyle. And Madam Speaker, the first time in my life that I contemplated living in situations where the norms that I had learned would no longer be valid in that situation. They're telling me if you meet a fella, wink at you, cuff him down and hope you win. Because if you lose, you're in trouble. When I checked, they told me the number of people in a small area. Those are the people we have to protect in this parliament. And it cannot be just lock up the poor. Madam Speaker, the burden to prove innocent falls disproportionately on the poor. We are aware of, and I don't want to say this, no? we are aware of instances where children of the wealthy can get away. We are aware of that. I don't want to go there, Madam Speaker. Madam Speaker, but in order to ensure more balance in the operations of this law, why not in a pari passu manner, introduce framing legislation which will make it a non-bailable offense for an officer of the law to frame an innocent citizen? Madam Speaker, if that were done, there would be an equal reticence on the part of the officer, and that could balance the deprivation of the rights of the average citizen. Senator Vieira, Madam Speaker, made the point in the other place that each case is different and should include weighing factors such as past criminal history, flight risk, potential danger to victims, or the seriousness of the charges, and therefore it is not fair to have a blanket clause which denies bail. Not fair. Not fair, Madam Speaker. There are mitigating circumstances which some adjudicating officer must examine and see whether there is merit in granting bail. This legislation, by taking away, and I'll get to that, this legislation, by taking away that discretion of the judicial officers, denies the citizens of a fundamental right. Madam Speaker, why not, and I'll get to the point of exceptional circumstances, which is loosely written. And I read in India where there's a reason why it is loosely written in the Indian context. But why can't we not use the intellect we have? We have bright people. We have Mahasabha schools. I have Naparima College, Madam Speaker. I mean, that produce brilliant people. We could put our brains to come up with a framing situation that could guide the judicial officers in exceptional circumstances. Madam Speaker, exceptional circumstance allows a person to apply to the court for bail in what they call exceptional services. The AG in the other place made reference to section 5.7a, that 7a, and I quote, notwithstanding subsection 3 and 7, a person to whom those subsections apply may in exceptional circumstances make an application to the court for bail. Madam Speaker, this has been used as a basis for claiming that the judiciary is not entirely excluded from the process of granting bail in these circumstances. Madam Speaker, why are these circumstances not listed as was previously done in other laws? Madam Speaker, I ask the question, which inner city youth will have the financial resources, Madam Speaker, to hire top quality lawyers needed to successfully argue this case. Madam Speaker, are we in this country passing laws for one segment of the society and not the other? Why are we not empathetic enough to understand that there are citizens in need? And I said it before in a previous debate. But for the grace of God, some of us would be in that circumstance. And we on this side will ensure that we protect the right of the poor, the halt, and the blind, and the lame in our society. That is a spiritual injunction, and no amount of insults that come from that side will stop us or get us to change from the spiritual path that we are on. For example, in the Bail Act, in section 6.2, and I quote, where the offense or one of the offenses which the defendant is accused or convicted in the proceedings is punishable with imprisonment, it shall be within the discretion of the court to deny bail to the defendant in the following circumstances. They have prescribed it. Heaven's sake. Not lazy legislation. You come 3 months ago with a piece of legislation, you didn't think it out well, you rush us in 3 months after, and you may very well rush us into another debate 3 months hence, as situations arise. So this is legislation by VAPs and not serious intellectual contemplation to come up with the best legislation. So it continues, where the court is satisfied that there are substantial grounds for believing that the defendant, if released on bail, would fail to surrender, or B, would commit an offense while on bail, or interfere with witnesses, and it goes on. So what we are asking for is that the judiciary, and even then, we know they wouldn't give it, because they are on their narrative, Madam Speaker, is not to agree with anything we say. And then when we do not vote, or if we abstain, they run on the platform and say, you see them, they're unpatriotic, they don't care about crime. I want to say today, we care about crime, and we will do what is necessary. We will do what is necessary to enforce the law and make sure that criminals are where they are. And Madam Speaker, they keep talking about convictions. Sorry, not convictions. They keep talking about arrests. Everything is arrest, and how much arrest. And I am not interested in arrest. As far as I'm concerned, a person is innocent until proven guilty. I am interested in convictions. So when you tell me that the anti-gang legislation is working and it has utilitarian value, I do not want you to tell me how much arrests have been made. That is easy to do. I want you to tell me that the process that we have inherited in the judicial process, that the person has been convicted. Madam Speaker, we came in July to discuss certain amendments to the Bail Act, and the bill was passed. No one expected that before the House we'll be discussing today further amendments. Interestingly enough, in September, the Commissioner of Police expressed certain concerns in a situation that took place and is now before the courts. 1 month later, 1 month, no consultation with any, at least not the opposition, no consultation at Joint Select Committee. The stakeholders have not been, as far as I'm aware, involved. They sat down in their room, in their ivory towers, and conjured up this legislation. And, Madam Speaker, the question we ask, what is the data? Don't tell me so many people were arrested from 2010 to now. How many people were convicted? And therefore, I will know about the efficacy of the legislation. You need to tell me with a straight face, right, whether we are not locking up more people to overburden the prison system, to make remanding yard a place that is totally, absolutely uninhabitable. Madam Speaker, that could be an unintended consequence of this penchant for locking up more and more citizens of our country. Madam Speaker, will this overburden the prison services? We are told, you read the 44, exactly what I'm reading now. You are told that 44 persons have been charged with submachine guns over the past 10 years. That is Hansard, November the 12th, 2019, page 33. Madam Speaker, that again is an example of arrest and no conviction. Where is the data on convictions? We are therefore premising this legislation mainly on arrests, Madam Speaker, not convictions. And there is something inherently wrong with this, Madam Speaker. We are not premising it on factual information. Madam Speaker, the question about if the question.
Order 53(1)(e).
Okay. Madam Speaker.
Members. Member for Digo notice, I promise you that you will get an opportunity, if you so wish, to join the debate. I'll ask you, if in the meantime, if you will kindly listen in silence. Thank you very much. And remember, this is not a conversation. Member for Naparima, please continue.
In the context of consultation, I recall in the last debate that in 20...
You know, Member for Puchis, you raise a certain standing order, but like, no, you see, we having a conversation. You are yourself falling into your same trap. Member for Naparima has some precious time left. Please continue.
Madam Speaker. Madam Speaker, I beg for injury time, please. Right? Madam Speaker, in the context of consultation, the Law Association raised some concerns about the bail amendment back, which are relevant today. And I'll just quickly, they raised two fundamental issues that neither piece, the was speaking about the bail bill and the anti-gang bill then, and now anti-gang law. Neither piece of legislation has acted as a deterrent to the commission of serious crime. Madam Speaker, I am yet to see the evidence that the suite of legislation is leading to a sour of criminals in prison. And the second concern, they say, the significant deficiencies in the forensic system resulting in unreasonable delay in forensic testing mean that persons are likely to have matters involving the use of firearm heard within the 120 days. Madam Speaker, I am of the view that we have suggested certain amendments. There is merit in these amendments. And if the government could only find it in themselves to stop being arrogant.
Again.
Stop being arrogant. And let us have a fulsome discussion on the merits or demerits of our suggestion, right, rather than an out-of-hand dismissal of our views. Madam Speaker, Eric Williams, the great Eric Williams, had an advantage. He used to take off the hearing aid when he felt that there were things being said that didn't make sense. Madam Speaker, so you'll have to forgive me. When the Honorable Attorney General speaks, I may find myself outside this room. Thank you very much.
Member for St. Augustine.
Thank you very much, Madam Speaker. Let me try to anchor this debate a little bit into the fundamentals of the society that Trinidad and Tobago has been and wishes itself to be in the future. Sometimes it is important to take a position out of the battlefield. 5 days before a local government election, we have debated in this Parliament a matter that involves the issue of bail, where one is entitled as of right to raise the issues of the criminality that has beset us even up to last night in our hospital. A place for recuperation and repair has become a place for murder. But I find it more than curious, Madam Speaker, that 5 days before general elections, this debate has come before us. I am not one to politicize this because it is so serious and so important, but I ask the question, could this have not waited till next week? Why is it timed like this? And worse than that, my dear friend, the Minister of National Security, said something that allowed me the certainty. Madam Speaker, I know the Minister of Finance, he might be very aggravated for other reasons. But he has promised to conduct himself, and he has broken that once again, like many other promises that he has made. I'm on the point, Madam Speaker, that here we are debating without, everybody says not to politicize, but I heard in this Parliament a most grievous statement from my very dear friend, the Minister of National Security, that for those who may oppose their position, that there is an ulterior motive. that we may have, and I say we because on this side, there is no distinction, because when you cast the blame, it falls on all on this bench. Now, I do not know if my friend intended the gravity of what he has said. And I pause. If it is in a parliament, you cannot take a position opposed to a government, because then you are accused of harboring criminality within your bosoms or within your friendship. That was the insinuation as clear as is daylight. And therefore, it is an attack on the democracy and of the very parliament, the very purpose of parliament, which to openly debate issues so that out of the debate will come better law for the people of Trinidad and Tobago. For too long, we've been regaled with the issue that if we oppose this government, first of all, that you're unpatriotic. Now it has descended 5 days before a local government election that if you oppose this government, you're criminal. Yes. My God. And then you ask, why is it that we believe, or the population believes, that you cannot trust the purpose of certain legislation this government brings? You see, I started off by saying we have to go back to fundamentals. And it caused me some grief when I had to look at the definition of a constitution. A constitution in a country is really that set of basic principles by which those who are governed agree to be governed, and the powers they give to those who are permitted to govern them. And as a result of that wide interpretation, Trinidad and Tobago, from its independence, had a constitution that protected fundamental rights. In a large part, it was replicated in the Constitution of the Republic in 1976. And I will, with your permission, reflect upon the society that Trinidad and Tobago agreed to become and has been and hope to continue. Because too often we get carried away by the rancidity of the arguments and the low-level thinking that it is all about power for the purpose of holding political control as distinct from power to help the people and to make a more perfect society. Mr. Speaker, when I look at the preamble of our Constitution, it is something I always have inquired whether it is taught in our schools. And to that end, the People's Partnership Government put on the computers we gave to our children the Constitution on every computer.
Some of the laws, yeah. Some of the laws.
And without ruining the moment, we must reflect deeply on our society, where it is said, whereas the people of Trinidad and Tobago have affirmed that the nation of Trinidad and Tobago is founded upon principles that acknowledge the supremacy of God, faith in fundamental human rights and freedoms, the position of the family in a society of free men and free institutions, the dignity of the human person, and the equal and inalienable rights with which all members of the human family are endowed by their Creator. And I shall move, that is A, to D. Recognize that men and institutions remain free only when freedom is founded upon the respect for moral and spiritual values and the rule of law. The rule of law requires us to have fundamental principles that guide us all. What is it in Trinidad and Tobago that we hold sacred in terms of our freedom? A country that came out of slavery and indentureship under colonialism and then into independence. The bright, brilliant future that we hoped for, and we said this is how this country will be moored. It will be moored on an understanding that all human beings are entitled to fundamental human rights. And the way to protect those rights have been put into our Constitution. One of the first and foremost things you will ask anybody in our society is if they understand the issue of presumption of innocence. But I think now that has been put more into the history books than into reality. When it is open to members of the highest office, the highest house in this land, to make allegations, to throw things out into the public sphere, to be consumed by those who may not truly understand that this is an era where truth really does not matter as much, to hear members who hold not just the highest office, but the most confidential of offices, speak about special branch reports, read it into the parliamentary chamber and into Hansard, and therefore disseminate it into the world, without naming persons, and rightly so, but to cast insinuations of criminality and criminal associations on the lawful members of the opposition is a direct undermining of the democracy of this country. I'm on the issue of presumption of innocence and due process. And if you'll permit me to again reflect upon this most sacred of our documents, the Constitution of the Nation of the Republic of Trinidad and Tobago, where at the preliminary at Section 1, the Republic of Trinidad and Tobago shall be a sovereign democratic state. What does democracy mean? It means that we all have a right to speak, but respectfully so, where debate must go, not just wide, but deep, so that out of that debate, we will find answers to very serious problems, and sometimes not lose sight. And I will return to this mooring of the society we want. If it is that we are to abdicate our responsibility of members of this parliament and suggest that whatever forces within the society call for that they must have, then there is no need for a constitution, then there is no need for a parliament, there is no need for court systems, there is no need for anything other than tyranny and for mob rule. There must be checks and balances in a society. To do otherwise will to create a future that nobody really wants, even those who temporarily hold power and believe that they're immune from the dangers of tyranny and mob rule. And let me explain what that means. When one looks at our Constitution, and in particular, Section 4 of our enshrined rights, Section 4 says, "It is hereby recognized and declared that in Trinidad and Tobago, they have existed and shall continue to exist without discrimination by reason of race, origin, color, religion, or sex, the following fundamental human rights and freedoms. A, the right of the individual to life, liberty, security of the person, enjoyment of property, and a right not to be deprived thereof except by due process of law." And then we go now to where it is expanded out to remove doubts at sections 5 to F that reads that Parliament may not deprive a person charged with a criminal offense of the right, 1, to be presumed innocent until proven guilty according to law, but it shall not invalidate by a law by reason only that law imposes on such person the burden of proving particular facts. 2, to a fair and public hearing by an independent and impartial tribunal, or to reasonable, 3, enshrined rights to reasonable bail without just cause. And this brings us to the crunch issue. The right to reasonable bail without just cause. My learned friend, the Attorney General, lamented early on and called on the member of St. Augustine and other members here to speak to the inconsistency that he perceived that will come if we are to object or not support this legislation, and reference indeed the issue of the anti-gang legislation, which we all had voted upon, and the issue of bail had arisen about first-time offenders. Let me put on the record, I, for one, like any person who is mature enough, will reflect on our past and look upon what we have done and see whether it brought success or it brought failure. If it is that we saw that something that we did in the moment of anguish, in a moment of desperation indeed, and then when one takes a clinical hindsight view of 2020 and realize, wait a minute, something went amiss, we cannot be too big to say that we were wrong. But I believe that there are those amongst us who are arrogant to suggest that what applied 100 years ago can be the same that can be applied today. we cannot create a new normal where, because we say something at one period of time, circumstances change, perspective change, you cannot revisit what would have happened. And I apologize, of course, because I was in a government that declared a state of emergency. Of course we apologize for it because, let me tell you for the record again, that there were persons within national security for the organization as such, who asked its government at the time, in fact not just asked, required of its government, because of information they had, that a state of emergency was required. And that had we not done that, there would have been a bloodbath. I don't know, for those who remember in the cabinet and the day, that this is what we were told, that if a state of emergency was not declared, a bloodbath would have ensued. What would a government do? And that is why I sympathize with my learned friends, because I am almost certain it's the same people who have come now to indicate, look, we need to ensure that there's no bail for any firearm offense like this. And it is important to appreciate that a loyal opposition must tell you their view, and if it disagrees, must disagree respectfully, but very strongly in relation to that. I tell you what, the People's Partnership paid a very dear price for many things, because we thought at the time, based on the professional advice and requests that were made of us, and we did what we thought in the moment was the correct thing, but we were voted out of office. You might not remember, and therefore I shall repeat. The issue of the state of emergency was demonized in the worst possible way, when members opposed to the government of the day, and now in government, had cast that as a racist attack on young black men in our society, where indeed thousands may have been arrested, and unfortunately, without justifiable cause, and the state would have had to pay. That is a matter of history. But do you think it was done with bad intent? It was not. It was done as a result of a government attempting to be as responsible as it could have based on the advice that was given to itself at that time. And therefore I ask this government today to reflect upon that history, and now as we go forward to see whether indeed what they are attempting, with the hope that they should have the opposition's help, is misdirected. Long history, judicial history throughout this world, has told developed societies, today developed societies, and in its time developing societies, that there must be a system of checks and balances. The age of the old monarchy has long gone. Long, long gone. We live in a modern world, and I had cause to reflect because I did A-level American history. It was the first class in this country that did A-level American history. And our teacher, Boris Punch, at Presentation College, would always have said that history really is about the present at the time, now looking back as a past. But history gives us a guidance as to how societies developed and how we today must look at ourselves, not only in the present moment, but understand that we have come from somewhere and we must go somewhere. And what we do today will determine the direction that we go. And there was a famous case in America, the Constitution, the United States Constitution, having been proclaimed in the 1770s or thereabouts. And in 1803, there was a case of Marbury and Madison. And that case had to determine a very simple issue as to whether a person would be entitled to a commission that had been granted. But the facts are really not important. But that case is landmark in American judicial history because the Chief Justice Marshall gave a decision that for the first time in American constitutional history gave and accepted and permitted the oversight of the judiciary over the Congress. The Congress had, of course, power to make law. But in Madison and Marbury and Madison, for the first time, the Chief Justice, by his ruling, accepted and put into law the authority of the judiciary to interpret law and indeed to strike down law that had been passed by Congress, duly passed. And I make this point because in Trinidad and Tobago, one of the first cases that came on this issue as to whether a duly passed law by the parliament, elected parliament, could be deemed unconstitutional. We had a history of this. In the case of Prakash Ramadhar and the Attorney General, argued by the late Fenton Ransohoy and my legal mentor, Ramesh Lawrence Maraj, brilliant man, who argued that there being a law that was passed for many years that cane farmers, whenever they had to sell cane to the sugar factories, money would be taken out of the sales from the farmers and paid to an organization. They had no choice in the matter. And that matter went before the court. The High Court agreed that it was unconstitutional, and the Court of Appeal upheld that decision of Justice Isaac Hartel. It's good reading when one has time. So it has been long recognized in this country that the parliament, as we say, is the highest lawmaking body of the land, always is subject to judicial oversight, always is subject to judicial review. And even though you do the proper manner and form requirements, for instance, as this legislation is, they said it requires a certain majority. Under Section 13, whenever any act is inconsistent with the Constitution, it must state so, and it must say what majority is required for it to be passed. And even after then, you will have all the manner and form requirements, as we say in the law. The court can still look at it and say it is unconstitutional because of Section 13. And the Attorney General is very well aware, and I know he really loves this area of law, and sometimes it's important just to refresh one's memory on it. It says at Section 13 of our Constitution, exceptions for certain legislation, 13.1. An act to which this section applies may expressly declare that it shall have effect even though inconsistent with Sections 4 and 5, and if any such act does so declare, it shall have effect accordingly unless the act is shown not to be reasonably justified in a society that has proper respect for the rights and freedoms of the individual. And this brings me to the point. You require a constitutional majority. The court, our constitution to which we agreed from independence and in 1976, gave the authority to the courts to make that determination, even if Parliament, with all the necessary constitutional majority and voted upon, the court still has an overriding discretion if the law is not reasonably justified in a society that has a proper respect for the rights and freedoms of the individual. What may have happened in the past, whether it was wrong or right, let us deal with what we are dealing with today. This attempt, and I will deal with the Section 7A, and my learned friends most admirably dealt with some of it. When my friend, the Minister of National Security, spoke to Section 7A, it speaks to exceptional circumstances that you would have access to the courts. I am not only on the issue of that the member for Naparima spoke to about the ability financially or resource-wise to access the courts. What is the definition? And Attorney General, I look forward to your help. I know you would have researched this, and I would like some clarity on it. That notwithstanding subsection 3 and 7, a person to whom such subsections apply may in exceptional circumstances make an application to a court for bail. What does that mean? Exceptional circumstances. The one thing I could possibly conjure up is, for instance, a person who is in custody without bail, falls gravely ill, and requires surgery or some other medical attention not available within the prison walls, or even within the jurisdiction, and may need to have to go elsewhere, and therefore would require bail so that he could have his freedom to access medical attention. I could see that. How rare an occasion would it be for a person to be lucky enough to have such exceptional circumstances? Think about that for a moment. Right, that is the point. You had to be gravely ill, about to die, before you could even access the issue of applying for bail. Now, Mr. Speaker, so that is no comfort to me that you have access. Because nowhere did I find, and my friend from Laventille West, maybe we could trash out a little bit more what the exceptional circumstances may very well be. I do not know.
He doesn't know.
So therefore, that is not, shall I say, a safety valve. Exceptional circumstances, because what would one do? And I heard it fall from the lips of my friends, that you can go to the court and say, oh, I was just a passenger in the car. That is your defense. That is not an exceptional circumstance to go and get bail. And if, for a moment before I should let it pass, and for people to believe that it is fallacy or false news or whatever you want to call it, that because you are the passenger in a car, that you may, just because you're a passenger means that you're immune from prosecution. Let me tell you, I actually did a case. Where's the member for Labre? Vecini is in Labre or is it Point Fortin? Yes. Labre, yes. You disown it quickly. Yes. Where a maxi taxi, that's my friend. Here I have a very good relationship. Yes. A maxi taxi. Where's the member for Sama Barataria? Yes. I remember the case well. A large maxi taxi with, I think, 20 persons or so. A 24-seater, yeah. Went down to Vecini for a day of frolic and fun. Beautiful music, I understand. Beverages, as my friend from Orapuch East will say, was flowing, and everybody was having a very good time. And on the way up from Vecini back to Saint-Ouen, they stopped at a bar, I think, for refreshments and certainly for men's room and ladies' room purposes. And police were passing by, and the music, I think, was too loud in the vehicle. And they decided, you know what, we're going to do a search. Guess what? A firearm was found under the seat in a maxi taxi, and all 20-odd persons were charged. All of them, including two young ladies, two students from New York, who had come down only for that week and had to leave on the Tuesday. This is our weekend, it's a Sunday trip, Talparo. They came to me, fortunately, for me and to them, and we had to go to the court to seek bail. And at that time, I want to congratulate the DPP at the time, when he had heard of the circumstances and so discontinued against the two visitors because there was no evidence in relation to them, but everybody else had to face a trial because nobody could determine who owned the gun. And therefore, the law says that if you're in any vehicle, any room, this is it, it is a powerful thing, this thing called possession. Whether it be for drugs, whether it be for firearms, you are deemed to be in possession of the thing if you are there. And there's some level of knowledge and or control. And therefore, not being able to determine the police, I don't blame them. According to the law, the way they interpret it, they charge everybody. Now, imagine that. If this law today that they wish to pass, it would mean 120 days. 120 days. What happened 120 days ago? Anybody remember? What month was it 3 months ago? Okay. November? September. August, September, October. How many meals have we had? How many events in our lives? How many days and nights? How many things transpired? And you would be sitting in a prison that is well known to be overpopulated with almost demonic conditions. Yeah. For what? Because you have been charged. Now, if we had to turn our country on its head and suggest for a moment that you, because you are charged, you are to be penalized, that is what it is. I always believed that if there is to be a true presumption of innocence, if there is to be life and breath in our Constitution, this is the process that we must undergo. First of all, if there's evidence, you should be charged. 2, you must be given due process by access to the courts. 3, that you must have a fair trial. 4, if you are found guilty, only then will a penalty be prescribed to you. But we are turning it around now. And not surprising, because I hear all my friends on the other side speak. Hear this, sir. If you are found with the guns, they have already become judge, jury, and executioner.
The burden shifts.
Suddenly, you have been found with a gun. So the Minister of National Security, and I understand why, because he's very, very, what shall I say, intimately involved, as he should be, into, I don't want to call him hyper. But no, not even those words. But he's extremely invested in success, and I understand this. So there's a tremendous anxiety to act on things. So that anytime a police come and tell you, we get him with a gun, in the mind, you're already guilty. What have we done to the country we want? We have moved away from the presumption of innocence to a clear, not just presumption of guilt, but a presumption of guilt where you are being penalized before you have been tried. And that is where I have grave difficulty. And the mirror that my learned friend, the Attorney General, wishes me to look into, I have. And I looked into the past and I look into the future. And having regard to developments in the recent past, where after Email Gate has been closed with all of the international assistance a government and a state could have gotten, they closed the investigation, said no evidence, but our beloved Prime Minister and others said there is more. And therefore I wrote, despite the lack of evidence, they wanted a presumption of guilt on not just anybody, Attorney General. And I know you. You don't have an ounce of hate in your heart. You cannot conceive. No, that is a fact. He has been well brought up and well loved by his family, right? He does not have an ounce of hate in his heart. But I want to remind him. You know, everybody knows about the Nobel Prize. Gentlemen and ladies, right? You know about the Nobel Prize, right? Not Nobel. No, he's a noble man, but we speak about the Nobel Prize. How many of us do remember or know that Nobel, that family, got its wealth from what? You know what? Dynamite. They were the manufacturers. I can't say inventors, e.g. I know you know a lot about these things. And the dynamite of the day was used in construction. It had to blow through mountains in the Alps and so on, and create tunnels. And so it was a wonderful thing, a new invention that to create pathways for roads and railways and so. But you know what? Having Alfred, dynamite then became a weapon of war. So be careful. What may be in your mind? What already?
Your initial speaking time has elapsed. You have an initial 15 minutes. You care to avail yourself? Yeah, proceed.
Wow. So the point I'm making, Attorney General, be very careful that this wondrous gift you think that you will give to law enforcement will become explosive and damaging, in not just to people, but to the future of our democracy. And that is why we must pause. We must reflect on what we are doing and ask ourselves, is this law necessary? Now, there are many gifts that one would have been given, but I did not know the Attorney General was such a good dancer. He danced around the most important thing. You told us nobody raised their voice in opposition to this law. Sometimes we get tone deaf. Sometimes we choose to hear what we wish. But when noble members of our Senate abstain, that's a very loud statement. And I shan't name names, but persons who are well respected in the upper house did not give support to this with well-reasoned arguments. And you know, we keep hearing, seeing that I have very little time, I shall have to accelerate and move now so that we will not be drawn into untold issues, unspoken to. When we look at the Bail Act itself, at our paragraph at section 11A. It has been referenced by many, but it is important for us to actually look at the wording, Mr. Speaker. Where an application is made to the High Court under section 11A and the High Court refuses or grants the application or varies the condition, the accused person or the prosecution, as the case may be, may appeal the decision to the Court of Appeal. Where the Court of Appeal hears an appeal under the subsection, the Court of Appeal may make an order, any order as it thinks just. No appeal shall lie from an order of the Court of Appeal under subsection 2. Now, the reason I went to that is to show you that the judiciary is well armored to deal with issues right up to the Court of Appeal. But at section 11(1), I just referenced 11A1. 11(1) says, where magistrate court grants or refuses bail in criminal proceedings or imposes conditions in granting bail in criminal proceedings, the High Court may, on application by any accused person or the prosecution, grant or refuse bail or vary the conditions. Where the High Court grants bail and so on, it goes on. The point being that the law already caters, and this is seriously important, the law written, produced, approved by the Parliament of Trinidad and Tobago already caters for a situation where a person or a group or whomever is unhappy with the decision of a lower court, that you have access to a higher court. It was asked. We're hearing about 9 machine guns. Oh my God, the way I feel, that person should have never get bail. The way I feel. But I want to tell you something, Mr. Speaker. Sometimes you have to be careful of what you feel, because feeling without thinking leads you to all sorts of awful things. In most of the cases I have done in the criminal courts, especially for murder, you will hear the accused say, oh God, I wish I could have turned back the hands of time. But I'll get so vexed, I'll lose, I wasn't thinking straight, sir. In fact, I wasn't thinking. Let us stop and think about what we are doing. So if there's access already to alternative, somebody asks a question and I really want an answer. In that case, that has brought around this whole issue of a person with 9 machine guns or whatever, the plumber case, I don't know if he's a plumber or what, but it has really thrown a wrench in the whole system. Because here, it has gravitated the country to believe, and remember for Aventil West, I know you follow these things in more detail. Were they full-form guns or they were just parts of it? Actual 9 full guns. Right? It astounds me that a magistrate, for whatever reason, I do not know the details, I am not to condemn, because I do not know all of the facts. There are subtle nuances, arguments have been raised there that allow the magistrate to exercise the discretion which the court is entitled to do. But if you are aggrieved by it, there is already a recourse. Did you use the available legal recourse? What is the response? To come with a nuclear weapon, a sledgehammer now on the Constitution, said bang, and say we're going to use a constitutional majority effort to deny you access to the courts. Is it that we are fed up with the courts? Are we going to say, look, enough of you all this thing about judicial review and oversight and all these laws, and then let's forget about it, and let's be very practical, get rid of all the people you suspect, throw them in jail for 120 days, and say that if they can't start the case in 120 days, then you could apply for bail, go back to the same court? Well, why don't you empower the courts by making the application? The DPP can do it. The police can do it. The complainant in the matter, a police officer, can do it. Was there access to it? Or was this so timed 5 days before an election to come here to lambaste the honorable members of the opposition that we don't care? Not only we don't care, you're unpatriotic. Yeah. And worse than that, you might be criminal. Yeah. Is that what we're dealing with here? Is that why we have come on a Wednesday to deal with these matters? Now, look, I may have been dazzled by some of the arguments, but I'm certainly not blinded. I'm not blinded to the reality, because as a country goes through difficult times, more than ever does it need to hold on tight to its moorings. Because today, It is the possession of firearms. No access to the courts. What happens tomorrow when the new flavor comes around? What, no access to the courts? And then again, another issue, another round, no access to the courts. Eventually, we're going to say, we don't need the courts. Let us be judge, jury, and executioner because a police officer says so. And for the record, Mr. Speaker, you are from Tunapuna, St. Joseph Police Station. How many would have remembered some time ago, not too long ago, they found guns up in the ceiling. Police station, La Brea, police station, guns again. What do you think those are there for? What do you think those guns are there for? Too often we have heard, and this thing about setup, it is real. I was in Sadiq Baksh. I know what happened that morning. Setup is real. There's a story that goes around because I heard it from a very senior prosecutor. Police has shot someone.
EG, please. Could you all speak in more hushed tones? Proceed.
That a person was shot in Skinner's Park. He was running away from the police. And they called this senior advisor. And he said, turn him around and shoot him in the front. I'm telling you, these are the things that happen here. So let us not, coddle the idea that people don't get set up in this country. I'm not saying it's widespread, but it's real. And as a result of that, as we were speaking about possession, deeming possession, I was involved in the Privy Council in a case, Sandra Juman, a woman who, I think she was from San Fernando West AG. She and her family. Police raided. They found a gun, 2 guns in a bag somewhere in a corner. They arrested everybody in the home. Do you know what Sandra Juman, you know what her fate was? She was blind. Couldn't have seen a thing. She too was charged. Had to go to court for umpteen times, and the case was ultimately dismissed. Poor Sandra Juman would have spent 120 days minimum in jail, blind as she was, innocent as her heart was, if this law existed then. So it is real. And my friends on both sides speak to the enormity of gun crimes. Let the police do their job. If they have reason to object to bail, object to bail. If they are unsatisfied with the magistrate's decision, go to the High Court. If you're dissatisfied with that, go to the Court of Appeal. Don't come to the Parliament and tinker with our Constitution, as fragile as it is now, because as we repeat, a country under the gun, a country in danger will allow us, sometimes the example is used as a thirsty man will drink canal water when he's about to die, and therefore we have to be very careful the cup that you bring and what you allow us to sip from. We have to be very careful of the poison chalice, because we are a society that will almost accept anything after all. Oh my goodness, we accepted a PNM government. So I wished you well. You've done what you considered to be your best. But this is not what the country expected. The country expects and needs more. We need people who have a vision, a wider view, not just for the year 2019, 2020, but beyond that. And therefore, what we do today will determine the kind of future, the kind of society we shall inherit tomorrow. Mr. Speaker, I thank you very much.
I recognize the member for Toko, Sandy Grandi.
Thank you very much, Mr. Deputy Speaker. Mr. Deputy Speaker, I rise to contribute to this bill, which is an act to amend the Bill Act, Chapter 460. So, Deputy Speaker, before I stand, I sat here for the past 2 hours, and I wondered if I was sitting in the chambers in Trinidad and Tobago, because I was saddled with a lot of unrealities. You know something, Mr. Deputy Speaker? We on this side, we are a strong party to represent all of Trinidad and Tobago. And you know, sometimes I sit here and I remember the story of the spider and the fly. you know, where the spider, the poem is, when you come into my palace, the spider to the fly. And some people, some flies are given certain position to sit, but they don't represent anything. They don't represent any people. So when they stand in this honorable house, they stand on behalf of their own selves. Impossible people, impossible statements, unrealistic statements, Mr. Deputy Speaker. Mr. Deputy Speaker, so that when I start this debate, I want to say, first of all, that Section 57 of the Bail Act give a defendant, always give a defendant, the right to approach the court, to appeal to a judge in chambers if they feel that they have a justifiable case. And all afternoon, Mr. Deputy Speaker, I've been hearing talks about somebody driving a car and they have a fireman in a trunk and what could happen to them and they could get locked up and they have some missiles in a water tank. And Mr. Deputy Speaker, we are in Trinidad and Tobago in 2019. And crime is at a critical state, Mr. Deputy Speaker. Mr. Deputy Speaker, we just heard the Minister of National Security speak about 80% of murders with the use of illegal firearms. 80%. Right, Mr. Deputy Speaker? That is critical. And then what I want to tell you, Mr. Deputy Speaker, I was a police officer 5 years ago. And you see that statement of 80% of murders with illegal firearms, that existed in the Port of Spain East, Laventille area. But you know what's going on now, Mr. Deputy Speaker? This has gone to the entire country. It has gone to critical proportions. I cannot stand here, Mr. Deputy Speaker, and every time I stand, I feel better, you know, because being in another place, he who knows it feels it. And when you know, you as a police officer, you have a government standing, and standing to ensure that they give you the tool or they respond to a request. That in itself tells you that you have a responsibility to our nation. But you know, as I sit here and I look across the floor, and that last speaker, Mr. Deputy Speaker, you know, Mr. Deputy Speaker, I'm speaking to you, because I want to remind you, and I want to tell you a story. And I have a story to tell in this house, you know. I was a police officer when the UNC came into office in 2010. And that person was among a group of other people who came to police headquarters. And all that they were intent about talking about is race and who they were seeing in front of them. And I could tell you as a police officer, and I'm talking the truth, you could go back and check. And I can tell you, I am speaking and I
48-6.
Other member for Sinaga State.
48-6.
Again, members, proceed.
I will quantify my statement now. I will quantify it now because what they were telling us, I was a senior superintendent at the time, and I was in an audience welcoming the new government of the day. And that new government was looking to us as police officers and telling us they were not seeing a proper representation before them on that day. And I wondered what was the meaning of proper representation. Every police officer in this land is sworn to the people of Trinidad and Tobago, and we are sworn beyond race, beyond every single thing to serve people, right? And when you are sitting there, and you know when I sit here, and every time we have a debate in this house, Mr. Deputy Speaker, and we have to pass a bill, the bill is consumed with discussions and discourse and arguments about who is rogue police officer and why you can't give the law to a police officer to engage in. And this is so minuscule because, Mr. Deputy Speaker, minuscule, I said again, minuscule. Minuscule. Okay, minuscule. Mr. Deputy Speaker, I'm going to speak the truth because I'm not in a court. You see, because you see in this honorable house, I always speak about who is honorable and who is not honorable, you know? And we have a way of giving stories and turning around stories, Mr. Deputy Speaker, to bring a particular meaning to something, right? So, Mr. Deputy Speaker, I want to refer to the key features of the bill. And Mr. Deputy Speaker, I fear nobody on that side. I am a strong woman, and I'm a strong PNM woman. Right? And I can stand because I have integrity, and I will stand and I will speak clearly. And I will always speak clearly. Because I ain't ready for all of that statement or making it. When you see the day come, I hope you all could stand up in court and say what you're saying in this honorable house. Continue, and I will challenge you all. Mr. Deputy Speaker, the key features of this bill relates to Clause 3. And Clause 3 of the bill provide for the inclusion of the offenses of possession of firearm or prohibited weapon for the purpose of trafficking under Section 9A of the Firearms Act, Chapter 1601, and possession of a prohibited weapon as offenses for which a person would be denied access to bail for a period of 120 days under the Bail Act, Chapter 406. The second issue, Mr. Deputy Speaker, is Clause 3 of the bill, which also seeks to include a new subsection 3A into this Section 5 of the Bail Act to define a prohibited weapon as artillery, automatic firearm, grenade, bomb, or any like missile. Mr. Deputy Speaker, I have been in constant communication with many officers, and when I saw the Commissioner express concern, I am pleased this evening to stand here in a debate where the Attorney General responded to the concerns of the Commissioner of Police, and I'll tell you why. Mr. Deputy Speaker, crime in Trinidad and Tobago and criminal activity in Trinidad and Tobago is of critical proportion, but the whole idea about crime in this country is that crime is a business enterprise. Crime is a criminal enterprise, criminal business enterprise. And when we speak about gang, we don't get the real meaning of what's really happening. Because we have persons, organizations operating there, and we call them gangs. But they operate as a business enterprise, where they employ people as shooters, they employ people as carriers. And, Mr. Deputy Speaker, I want people to understand that when we have young men being employed to carry certain artilleries, as this bill seeks to deal with, they are going with that in the waste because they are assured that for the first time being caught, they would get bail. And before they reach the station, I could tell you, before these people reach the station, the lawyer is on the step, waiting for the police officer to come there and to advise the offending person what to say and what not to say. And I have experienced that in time going by. And this is a loophole in the law. It has always been a loophole in the law where you find a person with a firearm and they were given bail even before you didn't even have time to put them in the cell in the station. They would sit out there and they'd fingerprint them, and before you say Jack Robinson, the lawyer is on the step to you. And these people get bail. And the next morning they come to the court with you. You looking more like the criminal than them. Because you sweat all night, putting your documents together, writing up your information, taking fingerprints, getting your witnesses, calling people here, there, and everywhere. And when you go to court next morning, you're sweaty, you even take a good bath, and you're facing a magistrate. And you see, I would talk like this now because, Mr. Deputy Speaker, the Minister of National Security, he laid the issues of the statistics. The Attorney General laid the law and the rights and privilege of the individuals. I'm going to tell you what it feels like. Right? And Mr. Deputy Speaker, I can speak of myself because I have passed through the organization in every single rank. And I have laid charges to people of that in that nature. And as a woman, Mr. Deputy Speaker, I had to go to court without even taking a proper bath and face a magistrate, right? And I can tell you, there were witnesses. When they come to court, they want to hide in a room. They're hiding in a room because they're telling themselves that person would get bail, or that person already in bail, and they come to look at that jacket and tie, looking snazzy as ever, and innocent as ever with a nice, smooth face, and we looking as though we are under trial. And this is the problem I have, Mr. Deputy Speaker, and I must bring it to the attention of the nation. Trinidad and Tobago must know what police officer engage in. And when you want to link your discussion, this whole discussion, this whole argument, this whole debate on rogue officers, you're going wrong. You need to look at the hard-working officers out there who live their life at risk every single day. Mr. Deputy Speaker, we have situations today where we have these young men who are, and I want to explain this whole concept of the business enterprise. You see, when a young man, they employ you, you do the job. They may put on about 20 work. And when I got 20 work, robbery, killing, and every work has a different distinction of salary. They could put on about 20 work. And you heard the commissioner say there's a person who committed 80 murders and he's still at large. We must never forget those things, right? So they put on work, right? And that person's still at large, so that person's salary keep going up. When another person is caught, so he will get bail, but his salary will drop because he's already caught. They put out money on bail on his head. I'm telling you, this is what is going on outside. And you see the opposition, they know, you know. They very well know what's going on. But they just decide today they're going to take a different stand because they have been in government and they know the principles, they know what is the operation. And that is the operation. So, Mr. Deputy Speaker, when you bring a law and you say first-time offenders will get bail, basically, and if a person, even as it was before, bail was applicable, then we are engaging in helping the criminals to conduct their business. That's right. Mr. Deputy Speaker, this bail act was before this very house. And I wondered why we couldn't go the distance. Because we left a big loophole. And many officers came to me and said, but girl, you were in the office, you were in the police service, you ain't even say a word. You know, we have an issue. We have a serious issue in this country that you have these young men and men, not only young men, men, women, being engaged and employed to carry firearms. And now we're talking about artillery. And one officer in particular tell me, ma'am, you should look at that prohibited weapon issue. And I was shocked to see that my AG had picked it up already, my Minister of National Security, they had picked it up already, and they were workers. I brought it to their attention, and they were already working on it because they understood what was happening in this country. This is what, and you know what I want to say, Mr. Deputy Speaker? There's a particular song right now in the airways about gun in a particular place, right? And the young people and men and women in this society, they have a little penchant with it. It's a kind of a fantasy, a passion. Thank you, thank you. Yeah, passion. To have these firearms in their waist, right? This automatic thing, and you see, they don't even want a Glock again.
Please, members.
Mr. David, they don't want a Glock again, you know. A Glock is no use. It is too slow firing. They want fast action. If you hear that tune on the market right now, gun in she hole, whatever it is, you will get the understanding of what's going on now. And it is as crude as it sounds, Mr. Deputy Speaker. And I am not going to put water in my mouth to say what is really happening in this country. Because, Mr. Deputy Speaker, listen to those on the other side. It seems as though, you know, they're from a different land, fairy tale land. You know, somebody from Singapore, you know, and talking about Singapore. And you know, Mr. I want to say something, Mr. Deputy Speaker. They always talk about crime dropping in America. But I want to read something here this evening. You know, the 8th Amendment to the U.S. Constitution provides that excessive bail shall not be required. And it goes on to say the U.S. Supreme Court has ruled that the Constitution permits holding a defendant without bail pending a criminal trial. And there is no absolute right to bail exists, right? And, you know, I look, and I'm going to continue, I look at the arrangement for bail in New Zealand and some of the guiding consideration. On one hand, they say a court must not unnecessarily keep people in custody who may later be found to be not guilty. But, on the other hand, a court must take into account that certain people who have been charged with or convicted of offenses that may pose a risk of harm to the community, that they may offend again or that they may fail to appear before a court. Mr. Deputy Speaker, in determining whether or not to grant bail, the court has to balance the individual liberties of the person charged versus the safety of the wider community, Mr. Deputy Speaker. But you know what I want to say, Mr. Deputy Speaker? In this House, we are giving consideration to the minority. We are not thinking that we have an entire nation to protect. Our country, we as legislators, we have a nation to protect, Mr. Deputy Speaker, and the nation which comprises of families, people, communities, schools, industries, the entire country, they have rights too. They, in the Constitution provides rights and privileges of freedom of speech, freedom of movement, and safety and security. And their rights are being challenged right now, Mr. Deputy Speaker. And when I sit here and I listen to the cries on the other side about one or two people who are engaged and they're thinking about it, what will happen to them, Mr. Deputy Speaker, you have to look at the bigger, greater good. We have a community out there talking to us every day, asking us what we're doing about crime, what are we doing about crime and criminality, and they're on the other side, they know the loophole. Because if you have a business and you want to make a profit, Mr. Deputy Speaker, you're looking for loopholes. You're looking for ways and means where you can make the best out of it. And in the same way, the criminal enterprise approach, they look for loopholes. So as we make a law here, they already have a way to abrogate what we do here. They already have a way in which they could engage to have the criminal activity running. And I'm telling you that, Mr. Deputy Speaker, our young men, we are losing our young men and in some cases our young women because they are being caught up in this establishment we call criminal enterprise. They are taking some of our best and our brightest people. I remember speaking to the last Commissioner of Police, and he was telling me that there was a young man in Laventille that they started to beat him. He was engaged to look for when the police come in. He had a job to look out. He had a period of time when he look out. And what happened? He stopped going to school. He stopped going to school because the time he had to look out, it kind of complicated his attendance school. And when they called him into the school and they decided to bring the police in, they realized that he could not go to school because he had a job to do. When he decided to come to school, the leader of the gang, they started to beat him, and he had marks all over his body. That is how it was discovered about this young boy in Silas, right? So, Mr. Deputy Speaker, when we sit down here, and I sit down so nice, dressed up here with nice perfume in my skin and comb my hair nice. And on the other side to everybody with jacket and tie, looking very honorable. And we're talking about Singapore. We're talking about America. America's laws are different. And we sit down here and we make references to talk about why our laws, our crime can't go down. And America, we engage with Mr. Singapore, Mr. Naparima. Mr. Deputy Speaker, we are unrealistic people here when we talk like that. Because you're talking about those countries in one way, but the laws of those countries are very different. I just read to you what I read about the type of conditions they have in America, in those states, in a particular state. And we'll come back some other day and they would say, you know, you have crime dropping in those areas. And why crime can't drop in Trinidad? Because the police are good, the government are good, the government don't know about stopping crime. But Mr. Deputy Speaker, this bail act we have before this House this evening, it seeks to do that very thing. I want to bring an example. You know, Mr. Deputy Speaker, for a civil matter, if a person is charged with a civil matter in an office, do you know that they are removed from the office? You know they are removed from the office, Mr. Deputy Speaker. Have you had any experiences like that? Where a person was charged with fraud in an office. They wouldn't leave that person there. And in this, but you have a man committing a criminal act, and you want to keep him in the society. You want to bring him back in the society. You want to bring him back to disturb the witnesses. You want to bring him back, Mr. Deputy Speaker, to kill off the witnesses too. You want to bring him back, Mr. Speaker, to be an element in the community to not only the witnesses' family. You have prison officers being killed. Mr. Deputy Speaker, look how much prison officers have been killed for this year. Their families' life being threatened. You have police officers' life being threatened. Right now I have been talking to an officer who wants to move from where he's living, right? Because his life is being threatened And it is all about persons before the court and they have been given bail for murders, right? Mr. Deputy Speaker, and you see, basically, sorry about that, wounding and robberies. Wounding and robberies, Mr. Deputy Speaker, because most of these offenses are committed with a firearm. So that when these matters are placed before the court, and persons have to give evidence, and these matters, Mr. Deputy Speaker, their lives are at stake. So when we sit here in this court this evening and we talk about how many murders we have had for the year, we talk about also, and I have to talk about murders too, because you have firearms on the street, every other person owns a firearm. And then when we talk about AK-47,
AR-15.
I mean AR-15. But I trained to use an AK-47, but I don't even know, I have never been trained to use the AR-15. And I can tell you what the AK-47 is about, right? Mr. Deputy Speaker, we are in serious times. Crime, we are in serious times. And to stand or sit in this house here and trivialize this thing and talk about a tank, a water tank. So, okay, something happened in a water tank. So what happened to that water tank? Where was that person? What eventually happened? Let's go back in history. What eventually happened? Right? And you see, they're just wasting, I like to say wasting court's time. We're just wasting Parliament's time. Yes. We're wasting Parliament's time. Come here and think about the people you represent. I mean, if you're given a seat, easy seat, you really don't understand what the people are going through, yeah? Because you get a seat, you sit down in a seat, you have one person, you represent yourself, right? You don't know what the people are going through because you don't have your constituents to come to you and tell you, listener, we're not safe. Another murder again. Another murder of the road. This lady gunned down because firearms all over the place. And when we talk about young men and women and men carrying firearms, Mr. Deputy Speaker, and when a police officer arrests a person for the possession of a firearm, Mr. Deputy Speaker, we have to send a message. We have to send strong messages. And the reason we have to send a strong message, Mr. Deputy Speaker, we must make this whole activity unattractive to the others. Because I'll tell you something, you know, Mr. Deputy Speaker. You know what criminals fear? They're afraid jail. They're afraid jail. They're afraid to death. But more importantly, they're afraid jail. Some choose to go in jail for protection. But the majority, they're afraid jail. They're afraid to get charged, you know, because they have lawyers lined up. And if they have to get another lawyer for another offense, they put on a bigger robbery. And it's all part of the livelihood. It's a livelihood in this country, Mr. Deputy Speaker. It's not a passion. It's a livelihood. People do that for a livelihood in this country. I have sat in this police service for so many years, and I've seen so many of them pass through. It is a livelihood. They live a short life and die. They don't really care about living old, to be old. They live for today, and it is a livelihood. It's a rough life, and they engage in that rough life. And when you see the kind of, when you go to their homes to do searches, and you see how they live, and how they don't respect cleanliness. And you know, cleanliness is not about richness, you know. Cleanliness is next to godliness. Yeah. Cleanliness is next to godliness. And when you see how some people live, right?
Speaker, 48-1, please. I can't take this side. 48.
What happened to Nancy?
Overruled.
Look. Ignore the vapid and vacuous.
So I'll go back on cleanliness. Cleanliness, Mr. Deputy Speaker, is next to godliness. And I still have to explain something because you see, I sat here and I listened. I have some other points I wanted to discuss, but listen to the other side. I realized they were totally out of it. They're not living in this country. You see, they are so hell-bent on not supporting legislation to make a difference in this country that they're not seeing it. They're not focused. They're not focused on issues that we are facing every single day in this country, Mr. Deputy Speaker. They are focused on being very unnationalistic, unpatriotic. They are focused, Mr. Deputy Speaker, that if they sit on that side and say this afternoon we're going to support this legislation, PNM would look good. This government of India would look good. So we're not going to support it. We're going to sit there and we're going to let it continue because you know why? They are in office. And then we have a few months or a year. It's time to get rid of that government. Don't support anything they come into this parliament with. So they can't understand the importance. They can't understand the importance of coming here on a Wednesday to debate a particular act, which I felt, when it came here in the first instance, it should have been already included. But nevertheless, it is before us now. And Mr. Deputy Speaker, they can't understand for the daylight. So what you do, if you have experience with the Deputy Speaker, you must take a little journey to the court. You see, because, you know, I heard it being said that those on the other side, they feel that they own the court. They feel that they know everything about the court. And they feel they know how to manipulate things in a court. So when we come here in this debate, Mr. Deputy Speaker, same thing applies. They come here not to seek the interests of the public of Trinidad and Tobago, a country that we have to deal with. But we seek to do the interests that we have at hand. We seek to keep that government there by being unpopular, to be unpopular, that we would not get good law passed. We are here as legislators. And I say every day, I may not be a lawyer. I may not be a lawyer, but I'm very bright. I was trained in criminal analysis.
48-1.
Yes. I was trained in criminology. And at the
48-1, sir.
Overruled.
Ignore empty heads.
Proceed.
Ignore empty heads.
Please, members.
So, Mr. Deputy Speaker, yeah, I have to talk about that because, you see, we talk about crime and we talk about what's happening in our country and we talk about legislation, right? And we talk about the need for legislation. But what we are facing in this country is a high level of crime and criminality. And every single time we do our legislation, I heard the member for Naparima say, you know, every time we come into a new suite of legislation, you see, he doesn't understand that crime evolves. Crime evolves. And as crime evolves, you have to bring legislation to deal with what particular issue is at hand. The crime of yesterday is not as today. Because as I started earlier, I said we had 80% of murders committed with firearm, and that only related to Port of Spain East. In those days, we used to focus only on Laventil and the area in Port of Spain, never anywhere else. But now, it is chaotic. It is all over. It is a culture.
Mr. Deputy Speaker, 55B, please.
That B is not agreed.
Overruled.
Mr. Deputy Speaker, you know, so I'll be relevant. I'll be very relevant now. Mr. Deputy Speaker, I'll be more relevant. Mr. Deputy Speaker, yes, I'm being relevant. Mr. Deputy Speaker, so being so relevant, I want to say to the other side, be more nationalistic. Be more nationalistic. You all don't like the word patriotism? I will say a new word for you all. Be more nationalistic. Support Trinidad and Tobago. Put all the people, put the majority of the people first. Right? Vote in this parliament today.
Please. Your initial 15 minutes has elapsed. You have an additional 15 minutes. Care to avail? Your initial 30 minutes, sorry. No, you. Yes. You care to avail yourself of the additional 15? Proceed.
I have so much to say. All of what I love. Mr. Deputy Speaker, I stood in awe 2 weeks ago when I saw my friend from Princeton being held up at gunpoint. Yes, on television. And Mr. Deputy Speaker, are we going to give people the license to walk around with guns and do as they please? Think about your colleague, you know, think about your colleague. You know what's going on with your colleague right now? I saw him take leave today. Mr. Deputy Speaker, you know what is going on with that colleague of theirs right now? They're at risk. They're at very high risk. Whenever you are invaded in a robbery, your life is at risk. Your family is at risk. Because robbers, they come back at you. They hit you once, they give you a second hit sometime. And that is reality. I'm not threatening anybody. I'm just telling you all the reality, what's going on in this country here. It's a criminal enterprise. They target people, they deal with people. If they deal with people and they realize they're going to come at them, they come at you. And are we going to leave it like that? Are you all going to think about your colleague? And you're going to leave it like that? But ladies and gentlemen, Mr. Deputy Speaker, when we leave those people alone, they will come back to terrorize innocent people. They come back to terrorize innocent people. Some people, their homes have been invaded. They feel so helpless. They come back. And now, we are talking about the artillery. We are talking about prohibited weapon, where a man has the power to throw something in an area and destroy innocent people within a second. Mr. Deputy Speaker, this is serious business. This is a point where, you have to give the police all the power, all the privilege they require as far as within the law circumscribed. Mr. Deputy Speaker, and I am suggesting that we sit here in this honorable house this evening, and I'm speaking to those opposite, I really am speaking to those opposite because, yeah, I have to speak to those opposite, We have to lead this fight directly with the criminals. We have to lead the fight directly with the criminals. You cannot make 5% of your country have a whole country at ransom and just always come and put excuses and talk about police and police brutality and police rogue police. They are institutions who we must support. When you were in office and you were in government, you expected the police to protect you, didn't you all? I was the Assistant Commissioner of Crime in San Fernando, Mr. Deputy Speaker, and I didn't even know when that marijuana leaves south and reached in Port of Spain. Could you imagine that, Mr. Deputy Speaker? I wasn't even aware. And we sit in this house here and we talk all kinds of things here. I wasn't even aware. When I hear talk about marijuana leaving a house in Southern Division and reaching Port of Spain, it amazes me. You all were very well protected.
Shot Glenda.
So, Mr. Deputy Speaker, I am saying that, we need to support this legislation. I want to compliment the Attorney General. I want to compliment my Minister of National Security. He went to great ends to tell this nation the amount of firearms out there, the amount of killings out there, the numbers of killings out there, the numbers of robberies, the numbers of wounding with firearms, Mr. Deputy Speaker. He went to great ends to tell people of this country the situation that exists out there. And Mr. Deputy and Madam Speaker, this country, we cannot protect every single witness in matters. It is impossible. This is not the United States of America. This is Trinidad. It is difficult, and even the witnesses, they don't even like to enter the program. It is difficult to even keep them in the program. And these are the serious issues faced us, and I'm saying this, Madam Speaker, those on the other side know about that. They have been there. They know about it. They are pretenders. Right? And they are pretending they don't know, but I know you all know. And I need you all to support this legislation because it is important to the country. And as we face the people, as we face the public, and we talk to the public for the next few days and the weekend before election, we're going to tell the public all kinds of things about crimes. We're going to tell them every single thing we know. But are we going to tell the public that we sit here as legislators and seek their interests, the greater good, the greater amount of people? Are we going to do that? Or are we going to sit down here this evening, right, and pretend that we feel we live in a place where we have to protect the few people who are criminals elements in this country, who are the criminal elements in this country. And I tell you criminal by profession, not criminal by choice, criminals by profession. And it's about time somebody stand up here in this honorable house and recognize that we have criminals by profession, not by choice. Yes, and the police need to get the matters put together. So they need the 120 days. They need the 120 days, Mr. Napri. They need the 120 days to put the matter together, to get the witnesses together, to put the case together, to properly prepare their witnesses, to bring the matters before the court, to get a determination. We talk about matters not being completed. This law will help the police to be even more efficient, to having the matter completed within that 120 days, without the risk factor that their witnesses will be threatened. And Madam Speaker, we sit here, our witness life is always at risk. And we have to compliment witnesses who come forth and give evidence. We have to compliment witnesses who come forth and give evidence. And what is this government doing to protect them? This law will protect them until the dust clear, as the code goes, until the dust clear. Because during the course of that trial, I can tell you all, and you all claim to be lawyers, so maybe you all visit court from time to time. I can tell you all, the court is not a nice place to be in. The court is not a nice place to be in. It is a place where you're under stress to get your witnesses together, to influence the witness to give evidence, to keep them together, and to get them for that 120 days, that matter could be completed, and we could show Trinidad and Tobago, and to show all those men and women out there who are criminals by profession, that this government, we mean business, and we come out serious, and we intend to take action. We want all on the other side to support us. Come out and support us. If all the name man across there and woman, come out and support us. You could come with coquille broom. You could come with any broom. Once you come with a broom, clean your house first before you come across. Use the coquille broom and clean your house. And then come across and support this government with this legislation. Madam Speaker.
So yesterday then.
Madam Speaker. I want to end my contribution by coming back to Section 4 of our Constitution. And Section 4 outlines that we are entitled to freedom of movement, the right of an individual to respect of his private property, his family life, and his safety and security. I, as a member of parliament from my constituency in Toko Sani Grande, I want to be feeling safe. I want my constituents to feel safe. I want every one of them to feel that they have a right to be protected by the organization that is deemed to be given the responsibility to protect them. That is the Trinidad and Tobago Police Service. We say after God is police, we still call police. After something happens, we call police. And we as a government, we have to stand here strong in support of all our organizations. The police service, the prison service, the fire service, the defense force, the army officers out there who are working with us on the ground. We have to show that support to all of those organizations. And built in those organizations, Madam Speaker, there is a facility which is there to deal with rogue officers. Investigation, as my colleague for Laventille West outlined, there is the facility there, the institution there, complaints authority within the organization to deal with rogue elements. And it is always going to be there to protect this nation. Madam Speaker, I still end to tell you, Madam Speaker, this evening, I call on my colleagues on the other side, be nationalistic. I'm not going to say patriotic. Be nationalistic. Think about your country. Think about your children. Think about even the young men who are lured into an occupation of crime and carrying guns as gun carrier, gun toters, young women who are carrying gun toters. Think about what's going on in our country. Think about the songs you're hearing in the society about gun and how that is a fantasy among young people and people who want to engage in crime and criminality. And sit down in your seats with your nice jacket and tie and your perfumes under your arm and support, Madam Speaker. I'm sorry to go so deep, but I have to go deep, Madam Speaker, because I sat here and I could not believe I was in Trinidad and Tobago. I felt as though I was in an island far away, just bounded with water and no crime. This is a country where crime is of critical proportion. The Attorney General is trying his best to bring legislation to make a difference in this country. The Minister of National Security continues to work assiduously to make sure that we give the organization what is required. Let us pass good legislation. Let us stop the gerrymandering in this parliament. Let us pass good legislation, Madam Speaker, and let us get the job done. We, on this side, we are getting the job done. Come on and support us and get the job done. Madam Speaker, I thank you.
The General, Leader of the House.
Thank you very much, Madam Speaker, in accordance with Standing Order 15.5, I beg to move that the House continue to sit until the completion of the matters before it. Thank you.
Honourable members, the question is that this House continue to sit until the completion of all the matters before it. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Thank you, Madam Speaker. Madam Speaker, I would like to begin my contribution by saying that I sat riveted to my seat in this chamber, listening to my colleague, the member for Toko Sangre Grande, and I wish to express my profound admiration for her contribution this evening. It is one of the best contributions I have heard, because the honourable member came to speak tonight to the people of Trinidad and Tobago in the reality of Trinidad and Tobago. And the honourable member, in fact, laid onto the Hansard record, and I adopt everything she said fully, because when there is the pepper and heart principle applied to what this law means when a court is looking at it, I want the record to say that I, as the mover of the bill, whom they will look to get the interpretation, I adopt everything that the member has said, because the member has given the lay principle to Section 13 of the Constitution. Section 13(2), by which we allow the derogation of rights in the Constitution to be affected, to be put into gear, is where you look at not only 3/5 of the Parliament voting, but where you are looking at whether the bill is reasonable in a society such as Trinidad and Tobago. And it is the speech of my colleague, the member for Port of Spain North, St. Anne's East, St. Anne's West, and the member for Toko Sangre Grande. They laid the fabric of what Trinidad and Tobago looks like, and therefore why this bill is reasonable in this kind of society. Madam Speaker, the cameras look at us as the main speaker. Tonight, as I wrap up this legislation, I'll be the only person in full frame apart from those behind me. And therefore, Trinidad and Tobago will not know that there are only 3 members of the UNC bench in this debate. 3 members.
Run.
Not a single member of the Parliament occupying the other benches opposite us are present, other than Pointe-a-Pierre, Caroni East, Oropuch West. That's it.
All these people who spoke.
If we wanted to pass this bill tonight, Madam Speaker, there has been a sabotage by the opposition. You see, we are required to have 3/5 of the votes of the Parliament, the House of Representatives. And Madam Speaker, I'll give way. Are you voting in favor of the bill? Oropuch West. Sorry, Oropuch West, for a moment there, I realized when the whip is not present in full form tonight, but I realized because a whip's job is to keep the bench populated. So we didn't see the member for Siparia, the leader of the opposition, Mrs. Prasad Bisesa, SC, member of the inner bar. Everybody else has gone. So, Madam Speaker, when we look to the constitutionality of this bill and trying to pass the law tonight, we're in difficulty because the opposition, even though they are paid to be in the parliament, they are absent from the parliament tonight. And that, I say, is nothing other than a crying shame, Madam Speaker. Madam Speaker, I'll get to Naparima soon enough because he promised he would leave. Picked up his tools and his bag the minute I started to stand up to wind up because he cannot take the flogging that he's going to get tonight yet again. And I mean an intellectual flogging, of course, Madam Speaker. He's not here to be flogged otherwise, but the intellectual flogging is reserved for a little while down.
Catch a flight to Singapore.
Madam Speaker, the Honourable Member for Urupuch East gave a good contribution tonight. I'll tell you why. Of the contributions coming from the opposition bench tonight, he tried to put sensible arguments forward and pass them off as a good reason for not supporting this law. The member gave a good batting.
You must be here a different thing.
Effectively, what I heard the honourable member say that stood out at me was, why deviate from your policy? Why deviate from your policy? The honourable member sought to advance a position to say that we as a government advanced a policy of saying lightning ought to strike twice, put in quite simple terms. You ought to fall into the bail restrictions conditions. If you have a charge. That's what the lightning strike twice principle is. And the honourable member is correct. That's what the government advanced as a position when we brought to life the amendments in Act number 17 of 2019. But the honourable member, in hanging the hat on that peg, did not take a view of the fact that we had amended the Firearms Act after that debate. And specifically, Madam Speaker, for the record, the Firearms Act, Chapter 1601 of the Laws of Trinidad and Tobago, that was amended by legislation coming after the bail bill had been passed. And that amendment, Madam Speaker, coming in the month of August, I believe it was, that amendment took us to the introduction of, firstly, an offense of trafficking in firearms, and secondly, an introduction of offenses for the possession of artillery, weapons of war. And Naparima tried to raise a point to say that we were, as he called it, intellectually lazy. We could not understand the position. We're a government by VAPs. Naparima said, and in making his argument as to our slothfulness intellectually, said, why didn't they, in Act number 17 of 2019, why didn't they, in that July legislation, come with the law to treat with this? For heaven's sake, Madam Speaker, the honourable member expects us to introduce a restriction in the bail law in July 2019 for a law that did not exist until August 2019. I mean, how do you really go about passing yourself off as someone who has done some form of research, as Naparima says he did? Naparima arrived here tonight, slave-bound intellectually, to a spiral-bound document speech that he read from. In other words, then, Naparima made the submission that we needed to have put into the law in July 2019 something which was not in the law until August 2019. Not only did the honourable member think of it, he bothered to write it down, bind it in a spiral binder, and then read it out in the parliament. It was as ludicrous as the submission that came from Naparima, where he said, and I really have to put this onto the record, the honourable member said to the parliament that There was no talk to stakeholders, no consultation. He then said, tell me with a straight face if you're intending to fill up the jails. And listen to what Naparima said. They are premising the law on arrests. We want convictions. Madam Speaker, as Tabakit and intellectual returns, Naparima, in a shrill tone, said to us, you are premising the bail law on arrests. We need to premise the bail law on convictions. Madam Speaker, you only get bail in the context of arrests. As to 99% of it, the law technically allows you to go for bail if you are convicted in an application to the court, the High Court, the Court of Appeal. But Madam Speaker, it is beyond intellectual absurdity for Naparima to be telling the country, let alone the Parliament, that we ought not to be talking about arrests. Well, when else are you going to be looking at the right to bail?
When they are charged. When they are charged.
But that's different than conviction.
When you are charged, the point at which you deal with an arrest, Madam Speaker, a charge and an arrest, Madam Speaker, come together. Madam Speaker, I cannot believe that the intellectual absurdity has now rolled its way down the bench, down to my learned colleague for Caroni East. Because, Madam Speaker, the law to treat with bail must be a feature of the arrest cycle, Madam Speaker.
Not conviction.
Now, Madam Speaker, there's something else that really struck me with the intellectual absurdity coming from Naparima. And that is where Naparima effectively tells the country that, and his entire contribution is that this legislation is taking away the right to appear before a judiciary in its wider form, be it the magistracy or the High Court or the Court of Appeal. Naparima stood up after the blurt of what I can only call to be racism in saying that we are not from Iraq. I am the only person of Iraqi descent here, and I take great pride in having both Trinidadian and Iraqi heritage. So I don't know where that goes, but for the record...
Standing order
48-6, please.
Overruled, continue.
Thank you. Yes, Madam Speaker, I, like many Trinidadians, my colleagues on the benches here, we come with ethnic roots from all over the world. China, India, Africa, in my case, partly the Middle East as well. I have no shame in saying that my family is a serious family from the Middle East and from Iraq and with roots in Tikrit. I have no understanding why that bothers the member for Naparima. But Madam Speaker, the honourable member sought to say that the case of Coriati applied. And the honourable member said that he would school me, firstly by saying that he had to correct me about the law of Singapore. And then he would school me in the law, like he had to school me in a debate when we dealt with the economic sanctions orders in relation to Iran. And I want to deal with those three things. Madam Speaker, firstly, the honourable member read partly from a publication online, which in fact I pulled up because it's word for word what he read. It is at the URL loc.gov, and it went through the summary of Singapore. And Madam Speaker, the phrase that he read, he only read part of. Singapore has one of the toughest firearms control laws in the world, according to its former Minister for Law, Professor S. Jayakumar. But what the honourable member forgot to read was the rest of the page, which confirmed exactly what I said in the context that I said it. And that is, of course, that possession of a firearm as utilized in the Singapore law can lead you to the death penalty. Yes. Because if you commit any offense, Madam Speaker, and do you know what those offenses are? They are scheduled offenses in the Singapore law. Do you know what they include, Madam Speaker? Larceny and graffiti. If you have a firearm for a minor offense in Singapore, you can find yourself subjected to the death penalty, Madam Speaker. So when Naparima comes to supposedly school the government, oh Lord, Madam Speaker, respectfully, I beg the honourable member to actually read the whole page, not just the headline, Madam Speaker. Madam Speaker, it's as egregious and untruth as when the member said that he had to school me in relation to the Iran orders. Madam Speaker, the member was caught in an unadulterated untruth in the economic sanctions orders. And when he was put right in the law and told that what he was reading was incorrect, Madam Speaker, he actually threatened to bring me before the Committee of Privileges. Madam Speaker, I'm still waiting 2 years later for the honourable member to do that. So I take no guidance from the member for Naparima on anything, and most especially the law, Madam Speaker. Madam Speaker, let's get to the point raised by the honourable member on the Coriati case. And the Coriati case is very important, Madam Speaker, because the honourable member, in making the submission as to what this bill supposedly is in his mind, because I'll tell you, Madam Speaker, this bill is not what Naparima said. This bill does not exclude the judiciary. The honourable member sought to read the Coriati decision, but the honourable member did not read the full aspect of what the quotation is. And I want to take you, Madam Speaker, to the State of Coriati, Mauritius, 2006, the UK Privy Council, UK PC 13, at paragraph 8. The exercise of granting bail is a judicial one, I quote. It is a judicial act in the same way as passing sentence must be left to the judiciary to adjudicate when and in what circumstances it must be granted or refused. It does go on to say legislation impinges directly on judicial proceedings if the statute itself amounts to the exercise of an inherent judicial power. This may, for example, be because it determines whether bail is to be granted. All of that is true. But, Madam Speaker, the case then goes on at paragraph 30 to say, I have come to the view that Section 2 of the 1994 Act did indeed purport to make a fundamental, albeit limited, change to this component of the democratic state envisaged by Section 1 of the Constitution. The crucial problem lies in the absolute nature of Section 5.3a. Where applicable, it would completely remove any power of the judges to consider the question of bail, however compelling the circumstances of any particular case might be. By contrast, a provision, for example, that persons of the type envisaged in the subsection should not be admitted to bail unless in exceptional circumstances would not create the same problems because the judges would still have significant, even if more restricted, role in deciding questions of bail and the freedom of the individual. Madam Speaker, I have just read what the honourable member omitted. And the honourable member has therefore misled this parliament into what the law is not by the government's draft, Madam Speaker. The honourable member for Naparima, who has fled the chamber, no doubt because he could not be the subject of being corrected publicly yet again, the honourable member left out the salient position of the judgment, Madam Speaker, as put out by both Lord Roger and Lord Mance in the Privy Council decision. And more particularly, the honourable member does not even have the intellectual courage to admit that the language of Section 5.7a of our Bail Act is exactly the same language that the case in Coriati upheld as being a permissible intrusion into the judicial exercise of the bail considerations, Madam Speaker. You see, the member for Naparima effectively has no intellectual courage, Madam Speaker. Certainly will not read the entire text, certainly will not put it into context, certainly will not tell us the truth as to what the ratio of the case is, but more particularly, does not have the intellectual courage to tell us that Section 5.7a of our Bail Act is exactly what both Lord Roger and Lord Mance considered to be permissible in the Coriati case. Madam Speaker, the contributions from the members opposite, from the member for St. Augustine, the member for Oropouche East in part, but certainly the member for Naparima, that this law is an ouster of the judiciary, Madam Speaker, is the furthest thing from the truth. Let me put it on the record again. Section 5(1) of the Bail Act, which is unamended and has stayed unamended effectively since 1994, when the Bail Act was brought into existence, that stays as it is, that you effectively have a general right to bail, subject only to the first part of the schedule, which is the capital offenses, and to subsection 2. Neither of which we seek to interfere with in the legislation. Secondly, we are specifically putting ourselves within the ambit of the decision from the Court of Appeal of Trinidad and Tobago in the Daniel St. Omer decision, which I, of course, put on the record in my piloting. In that case, Madam Speaker, we are upholding the right of someone to approach the court. Now, St. Augustine asked a question. St. Augustine said, tell us what exceptional circumstances means. And St. Augustine asked for it to be adumbrated and explained, etc. Madam Speaker, the reason why law is stated the way it ought to be stated is so that it can be interpreted as the law is intended to grow. It's called growing up in the law. The law must be allowed to breathe. Madam Speaker, let's take the example of the Constitution of the Republic of Trinidad and Tobago, the supreme law. Section 2 says the Constitution is the supreme law. But let's look at the very right to bail. Let's look at it in the context of Section 5 of the Constitution, 5 subparagraph 2F, Roman 3. It says that you cannot deprive a person charged with a criminal offense, notice what I said, charged with a criminal offense, of the right to reasonable bail without just cause. Does the Constitution list out all the reasons as to what just cause is? Do the framers of the Constitution see it necessary to say, just cause shall mean the following things? You see, Madam Speaker, I would expect better from St. Augustine. St. Augustine was the chairman of the Law Revision Committee. You know what that means? He sat down, as I have, and as Clarence Rambarat, Senator Rambarat, does right now. He sat down with the legislative drafters and went through the laws that come to the Parliament. Madam Speaker, surely my good friend, the member for St. Augustine, has heard of the expression "e justum generis." "E justum generis," which is a principle of interpretation, quite simply says, if you are going to set out in definitional terms what things are intended to mean, and you use qualifying words effectively at the tail end of the legislation, you are confined to that methodology of interpretation. In other words, it would be a savage atrocity to the courts of Trinidad and Tobago to have those exceptional circumstances defined in an "e justum generis" scenario. In other words then, Madam Speaker, you just don't do it. You leave it for the courts to interpret what exceptional circumstances means, Madam Speaker. What is important here is that everybody has used the example of framing. And we're talking about the maxi-taxi driver and the people in the bus or in a car, and Naparima was ridiculous enough intellectually to speak about a circumstance of you have to check a trunk before you get into the car. Madam Speaker, it's well known that there's a difference between constructive possession and actual possession. That things in a crocus bag, for instance, be it a dangerous drug or firearms, etc., that they go down to the role of actual possession. You have to have some degree of knowledge whether it is described as a strict liability offense or not, like dangerous drugs. In the dangerous drug scenario, where it is supposedly the case that your mental state of mind, your knowledge, your intention to commit the crime must be absent. You're not going to look at that. You're just looking at physical possession. Madam Speaker, our courts have gone so far as to distinguish that carefully so that you must actually have some degree of knowledge. It is open, therefore, to a court to receive an application under Section 5, subsection 7A to say, look, in the circumstances where everybody was taken down, I did not have actual knowledge of these positions, and there's certain degrees of hardship that I ask you to consider within the factors set out in Section 6, subsection 2 of the Bail Act, which are the reasons and circumstances that a judge can consider in the grant of bail, Madam Speaker. If that does not prevail before the magistrate, go to the High Court. If that doesn't prevail before the High Court, go to the Court of Appeal, Madam Speaker. That's what the Bail Act sets out in Sections 8, 9, 10, and 11 and 11A of the Bail Act. But you would never guess that the honourable members opposite read that. So this law is not about exclusion of judicial discretion. It is the opposite, Madam Speaker, because our law passed by Act number 17 of 2019, Madam Speaker, is entirely different from the law before it fell in 2016. Madam Speaker, Oropuchi said to the Parliament that consensus building is the way to go, that the opposition should be approached, that there ought to be a discussion. He reflected upon other Prime Minister's tenure. Madam Speaker, I want to remind that the Prime Minister and the Leader of the Opposition met, engaged in a system of exchange. Several of us who went to that meeting were then appointed to speak to each other. Madam Speaker, we tried that exercise and it collapsed completely. Oropuchis asked me to give an example of one anti-crime law that the government brought that the opposition did not support. And I'll name one. The income tax amendments. Exactly. Madam Speaker, when we brought the income tax amendments to allow the Trinidad and Tobago Police Service the ability to go and take your information from the Board of Inland Revenue, hopping and screaming, bawling and shouting, all mayhem broke loose, Madam Speaker. And you know what the government had to do? We had to strip down the 3/5 majority aspects, pass the simple majority aspects, and allow the law to come in. Perhaps we supported that. No, sir. No, sir. Madam Speaker, the honourable members are saying they supported that. The record will show they objected when I sat as in the committee stage and I stripped down the 3/5 majority provisions. Madam Speaker, they cried as if they were about to die, Madam Speaker, proverbially speaking, of course. So, Madam Speaker, that's one example. FATCA came by kicking and screaming. Anti-gang legislation by kicking and screaming. The Bail Act, Madam Speaker, let me give you another example where the opposition refused to support. You remember, Madam Speaker, that we came to this Parliament to extend the life of the Bail Act. Yes. Yeah. Madam Speaker, in 2016, yes, the sunset clause was coming. Correct. Yep. We came to extend the Bail Act. The Bail Act that they passed. Mm-hmm. The Bail Act that was the companion bill to the Anti-Gang Act. Mm-hmm. Madam Speaker, they had the audacity and lack of shame to tell this country, well, the Bail Act had its time. We didn't see any effect. We want statistics. And until we get statistics, we're not supporting. Madam Speaker, they died the Bail Act. True. It was amended from 1994 by 15 acts of Parliament, Madam Speaker, effectively. 14 or 15 acts of Parliament. Every last amendment that stood up to 2016 collapsed until we passed Act number 17 of 2019. Mm-hmm. Well, Madam Speaker, we learned our lesson, you know. We went to the Senate first. Yep. We made sure every single senator said yes. Exactly. And then when they could not look at that in the position of all the independents saying yes, with all the opposition, of course, saying no, Madam Speaker, they were shamed into passing Act number 17 of 2019. But they were shamed because we brought the Caballero and State of Mauritius type amendments. The Caballero is the case quoted by Naparima. It's trite law right now that these cases stand, Madam Speaker. The European Court cases have stood on our books. I've addressed that on many occasions. But Madam Speaker, the Bail Act collapsed. And we went back to a formula of law with 3 strikes, and you couldn't count convictions that were in 15 years of each other, etc. Madam Speaker, you see, the simple position is the opposition believes that they will prosper when crime is out of control. It's as simple as that, Madam Speaker. And I take no pause in saying it the way that I have, Madam Speaker. So, Madam Speaker,
that the opposition feels that they will benefit when crime is out of control. That is wrong. Imputing improper motive.
I just ask you to withdraw that and say that in a more acceptable fashion.
I withdraw it in the fashion that I said, and I'll put it this way. It is my respectful view that the opposition believes that they don't need to support certain laws which we consider are in the best interest of the people of Trinidad and Tobago, because they believe that the pandemonium that flows from that is somehow prosperous to their intentions, Madam Speaker. Madam Speaker.
Oh, come on.
It in a different way, but saying the same thing at the end of it.
Ridiculous.
Yeah, but you're saying the same thing.
Do you think, member for Karen East, what he colored it with saying it is his own view? Member for San Fernando West, continue.
There's an art to debate, Madam Speaker. I thank you for keeping it alive. Madam Speaker, the position is that our Bail Act, in particular as amended by Act number 17.
Member for San Fernando West, your original speaking time is now expired. You have 15 more minutes to complete.
Yes, Madam Speaker. The position is that our Bail Act number 17 of 2019 really is a radically improved version of the bail laws. We have managed to treat with the concept of constitutionality. And Madam Speaker, Naparima made a most bold-faced, lazy, foolish, intellectual submission. And I'll tell you why. When he stood up to read out the contribution coming from...
Member for Caronese, I didn't hear the AG say that the member was either lazy or foolish. I didn't hear him say either of that. So if that's what you're standing on, I overrule. Continue.
Yes, Madam Speaker. Naparima made a submission saying that the member for Diego Martin Northeast stood up in a 2015 debate on the Bail Act and said that he had concerns about constitutionality of the legislation and that it would only take one person to go to court to challenge that law. The member for Naparima gave way to the Minister of Finance, who put on record that yes, he said that. And the honourable member didn't quite catch what he was saying, Naparima. Because Naparima failed to understand that exactly what the Minister of Finance, then in opposition, said would happen is exactly what happened. Anand Ramlogan, past Attorney General for the UNC, went to court to challenge the law that the UNC passed on the ground of constitutionality for the exact submission that Diego Martin Northeast, then in opposition, made. Naparima thought somehow that he was making a point. Madam Speaker, all that he did was to prove that the Minister of Finance knows what he's saying and is an intelligent man. Naparima was bumbling with joy almost. His cup was then runneth over, as they say, running over with joy. But Madam Speaker, the fact is that law was challenged because that law was in fact a full ouster of the judiciary. That law was a complete ouster of the judiciary, and the honourable member for Diego Martin Northeast was right to say that. So, Madam Speaker, I don't know what Naparima was celebrating, Certainly, he seemed to be in a world of his own at that point. But, Madam Speaker, the submissions coming a little bit further also fail to understand where Trinidad and Tobago is. Oropuch Easton, waxing philosophically, said that the government had not yet faced the brutality of the law, and he attributed a Rousseau-esque type of view of our position. He said that we would soon come around to the Hobbesian view, of course, that life will be certainly short, nasty, and brutish, Madam Speaker. But, Madam Speaker, I want to put onto the record an article appearing in the Loop publication online. It's entitled, "Griffith Rifles Hard to Plant, Opposition's Arguments Baseless." And I want to read into the record what the Commissioner of Police, past Minister of National Security in a UNC government, member who saw the birth of the anti-gang and bail restriction laws under the UNC, has to say, as Commissioner of Police, fighting the criminal enterprise so capably explained to us by Toko Sangrigrandi in vivid form. Here's what the Commissioner of Police has to say, with your permission. Police Commissioner Gary Griffith is once again slamming the opposition for its position on the Bail Amendment Bill 2019, which they have labeled a reactive measure to fighting crime. The government is seeking to pass the bill to restrict bail for people held with illegal weapons and for forms of improvised explosive devices for 120 days. They then go on, Griffith responds, and here's what they quote Commissioner Griffith as saying. "I am amazed at the level of ongoing discourse in this matter. The red herring excuse by stating that a police officer can plant an assault rifle on someone, hence being the baseless justification to allow bail, is as ludicrous as it can get. What is this big fear and concern to ensure that those who have such weapons, which can kill hundreds of people in seconds, should be allowed back onto the streets?" That's the quotation from Commissioner Griffith. They say Griffith went on to say that based on the argument, every law should be abolished. He added that there are measures in place to ensure that police do not plant weapons on criminals. And then they quote Griffith again. "Refusal to prevent bail for such criminal elements by anyone simply means that individuals stating this, 'I am prepared to have a cold-blooded criminals who are actually held with bombs, hand grenades, or assault rifles being transported or in possession by them to kill, that they be released on bail to try to commit their crime on law-abiding citizens, based on the possibility that a law-abiding citizen could be given bail if one day, once in a blue moon, a rogue police officer would have tried to frame him." And then Commissioner Griffith goes on to state that it was the same government, then now opposition, that actually passed more restrictive laws. Madam Speaker, the Commissioner is able to independently testify to this country that the opposition, when in government, was prepared to pass draconian laws, laws which stood on the books of this country until they caused it to collapse in 2016, laws which were quite properly put on the books, in my view, to give us a fighting chance, Madam Speaker. And there's nothing wrong with a fighting chance. We in the PNM supported those measures, Madam Speaker. But today, when they are in opposition, all of a sudden, they have no difficulty in saying no to the law. Madam Speaker, Hansard will reflect Act number 11 of 2011. Ram Logan saying, this bill is about taking our country back, pulling the country back from the brink of the precipice in which the PNM left it. He said there was a need to include gang members. A message was being sent, the 120 days safeguard, sending a message to criminals, saying that there's no absolute or divine right to bail in this country. Those were the words coming from Prakash Ramadhar. Prakash Ramadhar saying at page 136 of the Hansard, Friday, December 10, 2010, there is no absolute or divine right to bail in this country. Dr. Suraj Ratan Rambachan, page 192 of the Hansard for Friday, one cannot be sympathetic in dealing with criminals. But today, we have to hear other spokesmen say the opposite of that.
The clown.
Fazal Karim, the honorable member in this house, page 113 of Hansard for Tuesday, April 19, 2011, in the Senate. This bill is necessary to fight against crime. This bill is for the Ram Logan in the Senate, criminal minority allowed to take hold of our communities. And then we had the famous statement from Anand Ram Logan, Attorney General for the UNC, jail air make to ripe fig. Madam Speaker, how far we have come, honorable members. From jail air make to ripe fig, to the member for Tabakit, member for Oropuch East, member for St. Augustine, every single one of them, under the most absent leader of opposition in our parliament, the member for Siparia, not here today again.
As usual.
On a bill as important as this, Madam Speaker, all of them then prepared to oust the jurisdiction of the court completely, Madam Speaker. And today, when we preserve the right of the jurisdiction of the court, the right to access bail under Section 5.1 of the Bail Act, under Section 5.7a of the Bail Act, all of a sudden today is a different story. So, Madam Speaker, can we genuinely take anything that the UNC says seriously? Madam Speaker, I'm looking at Pointe-a-Pierre with a look on his face of almost shame, Madam Speaker.
No, that's not possible.
Shame.
He has no shame.
Madam Speaker, Madam Speaker, this ties into what Oropuchi said, you know, when he was speaking about the need for a Hobbesian view on law and the brunt of crime, and said that, you know, there are elder parliamentarians who know better and they understand this. Madam Speaker, Tabakit has been in the parliament for how many years? 27 years, Madam Speaker. 27 years in the parliament.
Yeah, 27.
Madam
No,
Speaker.
no, you're not here 27.
Tabakit.
No, you're not here 27.
Certainly since the NAR days.
You're not here,
Right? Senator for 1 year. Has been in the Senate in the NAR years. Has been in the UNC. Has been in government. Has served in local government. My dear friend, the member for Tabakit, who I have a lot of regard for, that honorable gentleman fits the category that Oropuchi put. Oropuchi said that you can't have this Rousseau rose-tinted view of the law because you didn't face the brunt of the crime. So what was Chaguanas East, Tabakit, St. Augustine, and Oropuch East? What were they, honorable members, if not experienced parliamentarians in 2010, 2011, 2012, 2013, 2014, and 2015, when they passed the most draconian bail laws in this country? Madam Speaker, that is intellectual hypocrisy at its worst. And that is to play Russian roulette with our country. Madam Speaker, the OCIU, the anti-gang unit in the Trinidad and Tobago Police Service, that have been doing yeoman service for this country with intelligence-led facilities coming from the Minister of National Security, the law enforcement agencies, they tell us without a doubt that it is exactly what Toko Sangrigrani put on the record. Young men, young women, gun toters, gun minders, put to hold a weapon. These are the people most at risk in our society, Madam Speaker. In my own constituency of San Fernando West, I can testify to you that I know of these circumstances. And as we try to usher the most vulnerable in our society away from these things, Madam Speaker, there has to be a fear that the law will be applied. The law is not law without a sanction of law. The sanction of law must say is check once, check twice, check 3 times. Don't get caught with an artillery, gun, weapon, bomb, grenade. Madam Speaker, what are you doing with a weapon of war? You can't be talking about you want to protect this country and afraid to give the power Because, Madam Speaker, we are not proposing a law that separates the judiciary from its role. That's where we are different from the opposition, Madam Speaker. We preserve the judicial integrity and scrutiny under the separation of powers principle. It is there in the law. So, what are we going to do? Where does the axe fall? Do we protect the rights of Trinidad and Tobago in the en masse equation? The Section 4A right, the right to life? Do we protect that right? The utilitarian argument, the greater good? Do we look at those who are most inclined to this law and tell them, you need to be afraid of the law. You need to be careful of the law. You need to make sure you're nowhere near a weapon of war and you're nowhere near a prohibited weapon. You should not have more than 2 weapons. What are you doing with more than 2 weapons in your possession? Madam Speaker. Madam Speaker, we have taken care of the risk of the innocent being caught in the net. We preserve the judiciary's rights. The role of the judiciary is present in this law for the first time, Madam Speaker. We have done that. Is it proportionate? Yes. Is there a sunset clause? Yes. Is there a right of appeal to the High Court? Yes. Is there a right of appeal to the Court of Appeal? Yes. Have the cases in the United Kingdom spoken to this? Yes. Canada? Yes. European Star Chamber? Yes. European Court of Human Rights? Yes. Court of Appeal of the Republic of Trinidad and Tobago? Yes. So all of them right and the government wrong, according to the UNC. Madam Speaker, it just does not make sense. Madam Speaker, I urge the opposition to wake up and protect the citizens of Trinidad and Tobago. At least bother to come to Parliament. It is unacceptable to have 3 members of Parliament on the opposition benches for most of the debate. Madam Speaker, this law is proportionate, it is necessary, it is high time that we treat with this, and I beg to move.
Honourable members, the question is that a bill entitled An Act to Amend the Bail Act, Chapter 460, be now read a second time. All in favour say aye.
Aye.
Any against? The ayes have it. Leader of the House?
She needs to read it.
She needs to read it.
A bill entitled An Act to Amend the Bail Act, Chapter 460.
Leader of the House.
Thank you very much, Madam Speaker. Madam Speaker, in accordance with Standing Order 53, I beg to move that the debate on this bill be adjourned.
Honourable members, the question is that the debate on the Bail Amendment Number 2 Bill 2019 be now adjourned. All in favour say aye.
Aye.
Any against? The ayes have it. Clerk.
Clerk. Just to see.
The bill. Honourable members, we shall now revert to the item of business which was adjourned earlier in the proceedings.
Introduction of bills. The Finance Bill 2019 in the name of the Minister of Finance.
Leader of the House.
Thank you very kindly, Madam Speaker. Madam Speaker, I beg to move that this House do now adjourn to Friday, the 6th day of December 2019 at 1:30 p.m. At that time, we will do the Finance Bill.
Honourable members, the question is that this House do now adjourn to Friday, the 6th of December 2019 at 1:30 p.m. All in favour say aye. Aye. Any against? I think the ayes have it. This House now stands adjourned to Friday, the 6th of December 2019 at 1:30 p.m.